Serial number 28.
With your ladyship's
It-
permission,
it- Yes, from the memos.
mentioning your ladyship, this WP was disposed of with a mandamus by His Lordship Justice Krishna Dikshit. The mandamus expired. Honorable Family Court has directed us to take steps for extension. That's why for being spoken.
How can you take steps for
That is
extension?
the direction given to
No.
us.
It can't be. It has to be from them.
I understand. I'll
Yes,
submit this.
yes.
Obliged.
No, this is for a pending matter. The urgency is that I have been paying rent for my wife and now the owner is pressurizing me to either vacate the property or extend the rent agreement. My lord. The maintenance is under question in this WP. Maybe taken up for B group, my lord, under B group, my lord. It is final disposal.
Next week. Yes.
There is one more memo, my lord, where I am the wife and I am getting maintenance of only rupees 3,000 for myself and two.
Which year is that?
23, my lord. It
Let's
is
see.
part.
There are so many
heard,
matters of that nature, no?
My lord, it
Yes.
is part heard. my
Client
lord.
petition.
It was heard, it is heard in part. I was directed to file my affidavit.
Still
of
we'll
office
see
and liability.
after 2 weeks, yes.
But a client petition of wife is dismissed. Notice is served upon husband. Now matters may be taken for admission.
Which year is that?
24.
So your 24 matter, which is no notice served, has to be heard. What will happen to the other matters?
She is
We'll see.
Very-
No urgency for that. Yes.
We are the respondents, we are the son and daughter of the petitioner. Here they got a stay order in giving maintenance.
What is that? Your?
They got a stay order for a trial court maintenance order.
Oh.
So the daughters and the son was suffering from chronic and asking.
No, it's not a conditional order?
Already they got a stay order.
Is it a conditional order? Which year is that?
2022.
Yes, no, next week. Yes.
I got 2021 FA matter. OSS in 2016. Injunction was obtained on completely frivolous grounds. I'm the developer. I purchased the plot, my lord.
Which year is MFA?
The MFA is 2021, my lords.
Yes. Listed. Yes.
For the petitioner in this matter, the respondent is not giving the regular alimony. It's too difficult for me to maintain life and I have two school going
Which year is that?
22.
Lords,
After 3 weeks.
Lords, 2024.
We'll complete it. Again, you can't come from here. Yes.
Serial number 28.
Yes.
Lords, 2024 petition, Milords, Milords, the order of a trial court, Milords, custody was granted to the mother. Milords had heard the matter at length. Milords, matter was argued and the matter is today posted for mediation and which has been adjourned to 13th. Now, Milords, the urgency is that the child is having grave hindrances because his routine is being changed. He's not being sent to school and he's also being forced to do mountain biking. Milords and he has a condition of scoliosis which is being aggravated because of the forceful indulgence in mountain biking. Milords may kindly post the matter tomorrow for preliminary hearing.
Also tomorrow. Yes.
The petitioner, my lord. Petitioner is the husband and wife is going against the IA order, my lord. She is going for an execution, my lord. That is the reason I am filing this.
Which year is that?
24, my lord.
Yes, tomorrow. Yes.
Hello, it's for the appellant. 2015 matter, MFA.
What is this MFA or writ petition?
MFA.
Hmm.
The urgency is the appellant is very old and he is under the medical issue. So,
Yes, next Tuesday.
2015.
Next.
Please call the list.
Permission.
My lord, serial number
And
30.
unpleasantness yesterday, serial number 33, entirely on my side. Due apologies, my lord. I'll ensure it doesn't happen again. I think there was an overreaction on the matter, but it was not intended. Due apologies for the unpleasantness caused. Way forward, I assure the court that nothing of that sort will happen. I kindly consider my plea for apology.
Yes.
My lord, serial number 32, my lord.
Who's that matter? That matter on Tuesday.
Grateful.
My lord,
Serial
serial number
number.
32, my lord.
Yes.
Serial number
And for
8.
the petitioner, the advocate is not well.
Page wise adjournment, page list number 1, page 1, serial number 1 to 4, page 2, 5
Serial-
to 13.
Serial number 8, your lordships. Number 8, serial number 8, I am for the respondent in this case. I have informed the petitioner, a week's time may be granted, Your Honor.
Getting over a check of 20,000, 40,000 in this matter, my lord.
In 8.
In serial number 8, my lord. That may be kindly be recorded. They are seeking an adjournment.
At the request of Land Council for the respondent, post this matter next week. Land Council for the petitioner had handed over a check or DD.
Check.
Check of 40,000.
Check for an amount of rupees
40,000.
40,000. Yes.
Serial number 11, my lord, I am for. Prepare for reference.
Next week, it'll come up on 19th. Yes.
Serial number 11, my lord. I
Huh.
pay for aspirant, my lord, press time, my lord, my senior out of station, my lord. It was 1 week press time.
What is that?
11,
I paid per respondent, my lord.
Yes.
not NM,
Press time 1 week, my lord, our senior out of station. my lord.
Inform the other side. I request all the advocates, don't make a mention without informing them. 11 will reach, you can wait. Yes,
12, your lordship, 12.
yes.
Make it at 30th. Already negotiations, other side is also there. lordship. ಅದಕ್ಕೆ
Both the parties
ಅದಕ್ಕೆ
submits that the
30th ಹಾಕೊಳ್ಳಿ.
the
I will-
compromise talks are going on.
I will-
Pose this matter on 30th September.
Yes, your lordship.
Yes,
And
yes.
TA may be extended.
Interim
order.
order earlier granted is extended.
page number 3, serial number 14 to 18, page 4, 19 to 25,
My lord, serial number 28. Senior is a health
Page-
issue.
It says 19 to 25. 25, 8 comes later. Yes.
page number 5, serial number 26 to 29,
28, my lord. Senior is a health issues, my lord. I fever. Respondent.
Lakshmikant K for appellant,
You're for
Respondent.
the,
Respondent.
uh,
Senior is a health issues. in them.
correct. Have you informed Mr. Lakshmikant? Please wait if you have not informed. Yes.
page number 6, serial number 30 to 34,
Lord, serial number 30.
30?
31, my.
Yes.
For petitioner, we are complying the order of this court, my lord. So, today, senior is
Have
not-
you informed the respondent?
No.
My lord, I
Please
have
wait.
responded, my lord, in serial number 31, my lord.
He is seeking adjournment.
Lord, trial court fixed maintenance at 20,000. Your lordships not have restricted it to 10,000 as an
That also
increase.
is not paying.
He has been paying that, my lord.
So it
Last
has to be
date-
heard finally.
Please, my lord, last date of hearing, your lordships had paucity of time. Because of that, it was adjourned. Next week, if my learned friend has any inconvenience, it can be taken up next week.
Next week, give a date.
19-9, delete from chapter.
My lord, serial number 32, my lords.
Yes.
Serial number
35 and 36, my lord.
30?
35 and 36.
No.
Not yet called out that page, sir.
35, 36.
That page is not yet called out.
32, my lords, I'm for the
We
petitioner.
are withdrawing the
We
35 and
advocate
36,
on
my lord.
record. On the previous occasion.
32, what is that?
Yes, my lords, I'm for the petitioner.
Hmm.
We advocate on record, he was engaged in Supreme Court on the previous date of hearing. That's why it's listed for non-presence of the petitioner, my lords. He's not well, he has some viral issues. I'm instructed to take it for 13th, my lords, 12th or 13th this week if possible for the court.
Who appears for the respondent?
I appear for the respondent, my lord.
Anxious.
You have no objection?
Several times they have
12th or
taken,
13th,
repeatedly they have
my
taken, my lord. That's the
Yes,
reason it
that's
was
what
listed.
it appears.
2 days.
No, at the request of learned counsel for the appellant, finally next week, no further adjournments will be
My
granted.
lords, the date may be fixed. my lords.
17,
Tuesday it may be taken.
17, 17, 9.
Much obliged.
Much obliged. my lord.
Page number 7, cell number 35 to 39.
35, 36, my lord.
Yes.
We are withdrawing the appeals. The matter has been settled out of the court. My
It
colleague is there. He
Memo is
filed a
filed
memo.
stating that the matter is settled out of the court and they want to withdraw the petition and a memo is filed to that effect. Dismissed, memo is taken on record and dismissed.
35, 36. Great, my lord.
35 and 36.
Yes.
Cell number, page number 8, cell number 40 to 43. Page number 9, cell number 44 to 46, 45. Wish 2, cell number 1 to 4. Page, list number 1,
Fresh matter, MFA.
Hmm.
Fresh matter.
If the office objections are rectified, everything, it will come. For a fresh matter, no memo is required. Standard instructions.
cell number 1. Anand Biren.
Appear for the petitioner.
Bhushani Kumar.
My lord, there.
In this matter, we have deposited 1,50,000 during January and 1,35,000 in June, my lord.
Lords, I will verify with the trial court. It may have this matter by 2:30 minutes. Please.
230.
Yes, next.
Cell number 2. Somnath H. For petitioner. Deepa J. For respondent.
May please. There are two petitions, madam. May I request your lordship to kindly take 21834.
Yes. First. Filed by whom? 21834? both filed by the father, that is husband. Both the petitions. Both. Both petitions. Questioning what? WP 21834 is questioning? IA number? Visitation. IA number 3, my lords. Visitation. Now, my lords, I'll just pass on this. Take that synopsis. I'll be giving it in. The date of marriage is 2006. One child is 12-year-old and the other child is 7-year-old. Separation is 22 and GNWC is filed by the petitioner father for custody of children in 23. IA3 was filed by the father, my lord, seeking interim visitation. There was an order passed on this IA3, my lords, allowing visitation between 10 AM to 5 PM on every Sunday. 10 AM to 5 PM. Where is the place? My lords, both are in Bangalore only. No, where it is, which place, or you can take him? He can take him and drop the child. That's. Now, my lords, IA6 of 2023 was filed by the wife for vacating the ex parte interim order. Then, my lords, we filed the objections. Your lordship may kindly come to the next page. Then, my lords, orders were passed on IA, reducing the visitation from every Sunday to every alternative Sunday. Earlier, we had every Sunday. That was reduced by 2 alternative Sunday. And there was also an order awarding 40,000 rupees. That was challenged before this honorable court in a writ petition. 40,000 maintenance is granted to whom? To the wife. And also for the children. Altogether. It simply said 40,000 rupees.
It was ad interim order, isn't it?
Added. Now, my lords, that was challenged.
What happened
before-
to that writ petition?
That writ petition has been disposed. Next in my synopsis itself, if your lordship wants to turn to the next page, these are all admitted facts, no issues. 21, second column, 21 to 24. My lords, the matter was set aside by this honorable court and matter was remitted.
Yes.
Now, my lords, then we were given permission to file necessary application or whatever it is, my lords. Then 5324, my lords, IA11 was filed by the petitioner herein, seeking temporary custody of minor children for 1/2 of vacations, birthdays, etc., etc. Now, my lords, the IA11 was permitted. Thereby, they said, we can exercise the right of visitation on every Saturdays between 10 AM and 4 PM only in the month of May. Then, my lords, as far as IA3, which was already pending there, because that was set aside. 3, and they said you can file another application also if need be. So we filed 11 also. As far as 3 is concerned, my lords, the court reduced it between 11 and 2 PM. Now, in order to bring it. No. I number 3, initially it is on every Sunday, 10 AM to 5 PM. Then you said that it is modified to every alternative Sunday. Thereafter, we challenged before the High Court. Then the court said it has to be heard again. And if you want to make any other application also, we are free to make it. So 3 also. In that 40,000 itself, this is also there. 3, 11 were both heard together now by the trial court. 11 was also filed because we wanted during the vacations also. Now both were heard. Now your lordship may kindly see, my lords. Table. I'll just give the table so that your lordships will get a clear idea of. My lords, on the top, I have written IA3 and IA11, if your lordships were to see in bold letters. Synopsis next line. IA3 was filed, my lords, wherein in the initial stage, 3 PM to 5 PM, from Friday evening 3 PM to Sunday evening 5 PM, without respondent being there and telephone access. This was what was prayed for in IA3. IA11, your lordship will get it on the right side column. We wanted for half duration of the summer vacations, birthdays, and some family functions, and access through video calls. And we should also be permitted to attend the school meetings, my lords. IA3, my lords, first and third Saturday at visitation room of family court between 11 and 2 PM. Kindly see, my lords. What was all the interim arrangement that was made that has been drastically reduced to 11 a.m. to 2 p.m. and telephone access is given. Kindly come to right side, my lords, IA 11. My lords, they said petitioner husband is permitted to have access through video calls and attend parent-teacher meeting. The last column is important, my lords, fourth one on the right side on IA 11. The petitioner husband is permitted to exercise the right of visitation on every Saturdays from 10 a.m. to 4 p.m. in the month of May, in addition to the visitation rights granted in WP so-and-so. What is the order passed in WP is culled out here. So this is, when the matter was pending before this honorable court, there was an order that I can exercise visitation rights every second and fourth Sunday. Now, my lords, this is only with regard to May month. I am given in a way Saturday and Sunday I am given in a way.
Otherwise, it is alternative.
Otherwise it is 11 a.m. to 2 p.m. on first and third Sunday
So
in the mediation center. The reason for this is completely disturbing in a way. The court says, my lords, there is a straight WhatsApp message that is taken by the court below into consideration, where the father says, I will not beat the children. That statement has been taken. We were not confronted with it. And post this, my lords, I request your lordship, whatever was the date of the, assuming for a while it is taken on the, though we dispute it, assuming for a while that we consider that it is completely correct. I had in a way at one point of time on one day I had hit the child or whatever it is, my lords. Post that so many things happened and there was the cases were pending before this honorable court. Page 170 to 173 may kindly be seen, my lords. Page 170, 170 to 173. The photographs
No,
of
before that,
father.
we'll just look at the impugned order.
Pardon, my lords.
Before going into all that, we'll just look at an impugned
Please, my lords.
order.
Probably para 11 page 32 may be relevant, my lords, if your lordship.
I'm looking at the reasoning part of this.
It starts from para 11 is what I could guess.
Para 11.
11, page 32.
Yes.
May I read it here? On the other hand, the respondent mother heavily relied on the WhatsApp chats and emails to substantiate her contention that he is an abusive father and physically assaulted her and their elder son.
Yes.
The children are not willing to stay with their father. The WhatsApp chats produced along with the objection clearly shows that he apologized for beating the respondent and their son and also abandoned them
When
for
did
long.
he do this?
Well, it's March of 2022.
March of
The
20.
petition is filed.
No, before, my lords, a year before.
So it's
My lords,
That's
petition is filed after, my lords. The reason they had to leave was this.
This is what.
In
they
fact,
said.
my lords, we didn't
and
leave.
so because of all these, because of the behavior of the husband, you left.
No, my lords, he left us.
Whatever.
Yes, my lords.
It has all happened before all these proceedings are initiated.
But after also, there are, during visitation, my lords, in fact, the children are here if my lords wants to. The children are both here because we did not want to take an objection. There are multiple events that have happened during the visitation. In fact, right now, when the visitations are going on in the family court premises, the son is asking, please get us some water. He's like, no, I cannot buy you water. The policeman will arrest me. This is what he tells the child. He won't even get them water, my lords. This is the difficulty we are facing. My lords, there are multiple events even after filing. That is why the visitation was reduced. The first order where visitation was granted on all 4 Sundays was an ex parte order. We were not heard, we were not even served on that day. It was an ex parte order where visitation was given to the husband from 10 o'clock to 5 o'clock. The reason it was vacated and upheld by the Honorable High Court in a single bench was exactly this. What had happened was this elder son had a fever. The mother, when the visitation was happening, she still sent the child. He took the child to their Whitefield home. The husband took the both the children to the Whitefield home. The mother sent soup and said, please give this to the son. We have a message from the father saying, I ate the soup, I didn't give it to him. We have a message, we've put that on record, Malaj. I didn't want to say all this, Malaj, because at the end of the day, it's a father. Of course, he should have visitation, right? We're not saying that, but not to the detriment of the children. And Malaj,
So if it is detrimental to the interest of the children, alternative weeks, if they meet the father, is it not detrimental? What is on a weekly?
Malaj, when do I get to sit with the children? They have school through the week.
That's a different aspect. No, as far as the behavior of the husband is concerned, what loss, whatever injury or damage that you're apprehending.
I'm not apprehending.
No,
The
whatever.
child is apprehending.
If the child is apprehending, what can't happen on a weekly, or it's twice a month or on an alternative week? Won't it happen if it is on a?
It's in the court, Malaj. The reason the family court changed it was because they saw this. Malaj, what had happened was during the interregnum period, the children's cousins were all traveling to Georgia.
All the messages what he is giving to the mother appears to be with any of the disputes between them or the normal human psychology and conduct just to,
Malaj, it's fine, but you can't not buy your children water. I'm not saying this, Malaj, the son is right.
That's one incident. Then
It's not one, Malaj, it's two. Malaj, in the mall, when he took the children on the alternate weekend day, he slapped the child. The child came back with a bruise. This is the second incident of physical violence with the child.
what is that?
May I just,
There is a police complaint to that.
Yes.
may I just intervene? My lords, they said that there was an incident before
No, not before, after, while exercising the visitation.
absolutely no, my lords, absolutely no. But
Is it
whatever,
so? While exercising
my
the
lord.
they said
He
yes.
has also on one particular Sunday barged into their house without permission. Again, police had to be called. Malaj, no 498A, no domestic violence case has been filed
My lords.
by us. This is very particularly important because we did not want to incriminate him criminally. But this is the act of the father.
What are
No,
these
no, no,
temperamental
no,
issues
no,
the
my lords,
father is
absolutely
having?
no. My
Malaj,
lords,
they wanted their.
Yes.
May I just know? He's a qualified person. He's well decently employed in IBM in a good position. And maybe they had some issues between the spouses. Both come from very respectable families, respectfully. And then my lord, on one Sunday, he was supposed to go. Then the court, she was informed. He was informed that he cannot meet the child because the order is like this and it is changed from Sunday to this day. That's where, my lords, he did not have knowledge of it. So that's where he wanted to go there to see the child. Then at that point of time, I'm given to understand, she approached the police and then the police said, these are some issues that can be resolved between you. And he has to follow the court orders. He consulted the
The
instructing
police
counsel.
did not tell him that he has to follow the court
No,
order.
no, that was not brought to his knowledge.
Why it won't be brought to his
No, no.
notice?
He was not
You
there.
are
There
aware
was-
of an ex parte order, you
there
are
was-
exercising the
no, ex
visitation.
parte order was there.
No, you are aware of that order.
Please,
You are not aware of an order which is vacated.
that modification order, Mellors, there was a confusion.
That cannot be.
Mellors, then he went there. He thought that the Sunday visits, usually they used to go to church with the child. He requested, they said no. Then they came out. There was no FIR, nothing of that kind.
One thing is, if they can't deal their life in a manner which is good for the conducive environment for the children, he is not entitled for a custody at all. This is not a battle between him and his wife.
Definitely no. I would be the first person to say this.
How can he
Now,
slap the child?
Mellors, I don't know. They say that, and
So,
they
what
are
is the-
producing, and
When did this happen?
Malaj, the date
and no FIR, nothing, Mellors.
25th of February this year. Malaj.
It's good that she didn't. February?
25th this year. Malaj, I'll just explain what happened. My learned senior may not know why this happened. He came down, they live in Silver Lake Apartments, Malaj, on the Trinity Circle. He came downstairs, he called the children. There was an issue with regard to the passport of the children. Now, the elder son is an extremely mature child, Malaj. He has seen a lot of between the parents. He's very mature. All the cousins were going to Georgia on a holiday. Her father said, I will pay for the trip, no difficulty. But the children's passports were not made. They kept requesting the father. The father kept telling them, yes, I'll sign it today, I'll sign it tomorrow. And then he refused. So the children were extremely upset. Even if there was no visitation and he came downstairs, they went downstairs. They told the father, please sign this form, please sign this form. He said no. So then the children said, okay, then we're going up. In that anger, He came back upstairs, threw the door wide open, came into the house while litigation is going on. You cannot scare the children like this. He's afraid today. Every single day he is afraid. What if he hits me? What if he hits me? This is what he asks me when I tell him, why don't you want to spend time with your father?
May I
How
just-
do I tell a 12-year-old child? It's not like they're not mature enough also. They understand things. Nowadays, internet has made them more wise than we are. But how do I explain it to a child that this is not going to happen when it has happened, when a court order is granted visitation? How do I tell?
Father is there in the court. He is not there, nurse. I can get him, absolutely.
Let us talk to, then we'll pass on. We'll
Grateful, nurse.
Well, it's just one more point. Sorry. Malaj, there's a maintenance order also that they've challenged, which is item number 2. He's not paid a single penny.
I will just come to that.
No,
It's
may I
their writ petition.
Yes, yes. It's the same. Item
When is that? What are the dates? For the chamber.
Today, when, my lords, your lordship?
Today, I think there must be some matter today already.
Fair enough, nurse. Whenever your lordship directs.
Children are here, my lords.
My lords, I would request, my lords, if your lordship wants to interact with the children, fair enough. Otherwise, let children not miss the school every date of hearing. They are brought to the school, this one. I am
What
requesting that.
happens is there's no-
Today, there are about 2 matters in the chamber.
Fair enough, nurse. Whenever.
Give a date on that, it's in the evening. Children can go to the school and then come.
Please, ma'am, we'll do that. We'll do that. And in fact, I have no problem if the father wants to meet the children before meeting the judge. I have
No,
absolutely
no issue.
So that there's no
Absolutely.
allegation on us. Please meet the father. We have no difficulty. But
When is
just
the date?
these activities will do.
Pose this matter on 22nd. 22nd is holiday.
October, madam? September. No, that's a Sunday.
Pose this matter on 23rd, on the day.
23rd, I am not there, my lords. My colleagues will be there. Otherwise, 24th.
No, it's in the chamber.
Ah.
They're also fine because no arguments are heard.
That's
please,
20th possible.
Huh?
I'm sorry, I come all the way from Delhi. If 20th is possible?
20th.
Friday.
Any matter on that day.
Is it okay?
Friday is not possible.
Oh, okay. My lords, then 19th?
There are already matters at 5 o'clock.
I'm so sorry, my lords. Then I'm terribly sorry. May I then request?
25th.
26.
I'm in Supreme Court. My lords will hear arguments on that day or will just wait only. Then I'm not required. My lords, we can any date.
Pose this matter on 23rd.
Grateful.
At 5 PM.
My presence may kindly be,
Mother and the children shall be present before the court.
my presence
I'm
may
so
kindly be excused, my lords.
Yes.
My colleagues will be there. Grateful, nurse.
Serial number 4, serial number 3, Latif B.
Challenging the interim maintenance, my lord.
These two in that.
Challenging the interim maintenance. That way, there are 4
The
petitions.
husband,
Yes, ma'am.
how much is granted?
10,000, ma'am.
What is your income?
8,000. 8,
Come to the order.
yes, ma'am. Interim maintenance is granted only for petitioner number 1 and 4, my lordship. 2 and 3
For
are
the
staying.
petitioners. First
Wife
is the
and 3
wife,
children.
uh,
3 children, my lord.
3 children.
2 and 3 are staying with me only.
2 and 3 are?
Staying with me, page number 30, my lord.
So now it is given to 1 and 4.
1 and 4.
Oh. Please come to the discussion with regard to your income.
My lordship, page number 29.
20.
9. I filed my assets and liabilities.
Read para number 11.
My lordship, after 4 lines, on the other hand, the respondent has filed affidavit of assets and liabilities wherein he has stated that he is working as a coolie and earning 8,000 rupees. It is an admitted fact that I'm a painter, my lordship. She herself mentioned that I'm a painter.
The learned counsel for the petition submits that the petition is filed by the wife and 3 children. In fact, petitioners, the respondents 2 and 3 are residing with the petitioner. The court had granted maintenance of an amount of rupees 10,000 to the first and the fourth petitioner. He submits that he is taking care of the other 2 children. And his income is only 8,000. In spite of the same, the court had granted maintenance of 10,000. Considering the submission of the legal counsel, there should be stay or hold further proceedings. In the condition that the petitioner shall continue to pay 5,000 by
My lordship, 4,000.
4,000 by 5th of every succeeding month. What about arrears?
From
Petition
the-
is filed when?
December 2023,
24, 23.
please.
So 12 plus another 10 months, 22 months,
9 months.
no. 23 of
December.
December 20, yes. Just we are in 9th month, 10 months,
10 months.
50,000. And you shall pay the arrears at
40.
5,000 for 10 months. An amount of rupees
40,000.
4,000 for 10 months, 40,000. Within a period of 4 weeks from the date of receipt of the copy of the order. Same with regard to the notices also, hand summons, we shall file a memo to that effect by 24th of September. And if either the interim order is not complied or the memo is not filed, the stay granted by this court stands vacated. Post this, if the memo is filed, post this matter on 30th September.
Please.
Yes.
Sale number 4, parted matter. Dhananjay Kumar for petitioner, Sudesh Kumar Acharya.
Appearing for petitioners.
Shall we delete it from parted, let it come in its usual course? Passover. No, the more than the regular, this thing, Passovers are more every day.
Preliminary hearing B group, sale number 5. Sharat Gowda GB,
Here for the
petitioner.
petitioner, my lord.
Swami.
An application under Order 7 Rule 11 was filed, which came to be rejected, as against which this present writ petition is filed. Previous date of hearing, my lords, my learned friend made a submission that I need to file a CRP and writ petition is not maintainable. If I may persuade my lord to kindly take section 19 of the Family Courts Act, please.
Yes. Family Courts Act.
Section, sir.
Section 19. For Family Courts Act, my lord is well aware it's a special enactment. And section 19 deals with appeals and revisions which can be preferred from every order and judgment that is passed. Now, clause 5 would be relevant. I'll not trouble my lord reading the entire.
Yes.
Clause 5 says, except as aforesaid, no appeal.
19.5.
19 clause 5.
Okay.
Keep the latest books, all new amendment after the. Yes, you please read.
My lord, I may be permitted to read clause 1 first. Save as provided in subsection 2 and notwithstanding anything contained in CPC or CRPC or in any other law, an appeal shall lie from every judgment or order not being an interlocutory order of a family court to the High Court, both on facts and on law. So under section 19, we have to prefer an appeal, and we cannot invoke CPC and CRPC is what clause 1 would say.
Against the final order.
Against the final order, as well as against the order, as well as the judgment, it says. It doesn't say final order. It says from every judgment or order, it says. And if
That
my lord,
has to be interpreted. No,
it
against
also, insofar as the interlocutory order is concerned, my lord may kindly see.
What you see, if that has to be read, then against the drivers that is granted, you can come before this court and file a writ petition. Why
No,
should
it
you-
cannot be,
why
it
should you
cannot be,
file an
because
MFA?
no, under section 19, an appeal is provided. It says an appeal shall be filed under section 19. But I cannot be filed under order 41 is what the provision says. My lord, if I may persuade my lord to kindly take section 19 for a moment. Save as provided in subsection 2 and notwithstanding anything contained in CPC or CRPC or in any other.
Here, every judgment, an appeal shall lie from every judgment or order, not being an interlocutory
Not
order.
being an interlocutory order.
Final order and appeal
Yes,
lies.
now my lord may kindly come to clause 3 and 4.
Yes, sir.
Every appeal under this section shall be preferred within a period of so and so, so and so. Clause 4, the High Court may on its own motion or otherwise call for and examine the record for any proceedings in which the family court situates within its jurisdiction, passed an order under chapter 9 of CRPC for the purpose of satisfying itself as to the correctness, legality or propriety of the order, not being an interlocutory order, and as to the regularity of such proceedings. Now clause 5 may be kindly seen. Except as aforesaid, no appeal or revision shall lie to any court from any judgment or order or decree of a family court. What is this? So my humble submission.
Comes to your, the rescue or how it supports your argument. I'm not able to understand.
Lord, my submissions would be that because it attains finality, the order, the interlocutory order, though it's an order 7 rule 11, it's an interlocutory order that has been passed. Because it attained finality, my lord, there is no provision provided. It says clause 5 says that except invoking section 19 clause 1 to 19 clause 4.
The writ petitions are filed against an interlocutory order.
No, 227. I have to invoke 227. Yes.
Yes.
Under supervisory jurisdiction, I have approached this honorable court.
What he is submitting is an order in that form. Like it puts in the entire proceedings will be closed. Either way that impacted that it is.
Had the application been allowed, the entire proceedings would have been closed.
But there is another line of judgment where if an application under order 7 rule 11 is allowed, again it's such a regular appeal lies. If an order
Yes,
7
yes.
rule 11 is dismissed.
Then
it is
civil
such a
revision
regular
petition.
lies. Revision.
Yes.
Either under 227.
Section 115.
Proviso
to section 115.
gives you
CPC. His submission is under CPC, I have to approach this honorable court under 115 of CPC.
The revision lies.
The revision lies is the submissions that is sought to be made.
So what the procedure we follow in Telangana and Andhra is, no, we have no writ petitions for 227 revision. So either a 227 revision or a 115 revision, it is only a revision. Then only you mention it on that, it is under 227 or 115. So for there it is a revision for any of it. Now because here it is under article, only writ petition is under article 227, then necessarily it has to be under 115 as rightly put forth by him.
My understanding of section 19 was, Lord, because it's a special enactment and a special provision has been created only for the purpose of.
Your rescue at all. 19(1) as far as those appeals and other things were concerned. Appeals under the MF.
Not in that.
You can change it. What's the big deal?
I'll file a memo.
Just a matter of. It's already like somewhat as a CRP it is started.
I'll file a memo now itself.
Yes, the present writ petition is filed, agreed by an order passed and passed by the trial court on an application and order 7 to 11. Land counsel for the respondent has taken objection that against that he cannot file a writ petition under 227. Necessarily has to file a revision under 115. Land counsel for the petitioner submits that he'll take the necessary steps.
Please.
Accordingly. Writ petition disposed. Given permission. Writ petition dispose on
Hey,
dispose of.
For
giving authority
statistical
to the
purpose, the writ
petitioner
petition has to.
to file an to seek the.
No,
to
it
file
may
the
be
appropriate
permitted, my lord. I'll file a memo to convert the writ petition into a CRPC. That may be taken on record. I may be permitted to convert the CRP into a CRP. That is permissible, my lord.
Just to file another.
No, no.
Anyway, it doesn't make any difference.
No,
You can
what
do
the
it.
difficulty would be, my lord, then if I have to prefer a CRP, the delay and all the other aspects will come
No,
into
when the
picture.
court has given you permission, then the delay won't arise. Section 14 is there.
Section 14 is there, but the practice is, my lord, that we file a memo seeking permission of the court to convert the writ petition into a
It
CRP.
happily file a CRP afresh, where the liberty is given by the
Please,
court.
madam.
Yes, next.
Please. Grateful.
6. Nataraju T.
Is in this case, my lord.
Petitioner.
Respondent in this case.
Venkateswar.
Husband petition, my lord, challenging the orders of the trial court, wherein, my lord, an application filed by the husband, who is the petition before the trial court, is dismissed. The application, my lord, sought for a direction to the respondent to undergo for a medical test, proving herself that she is an impotent. Because, my lord, the petition is filed under section 12 of 1, saying that, my lord, she is an impotent. The decree of
That's allowed
that is not allowed. The original petition is filed before the trial
for
court.
the,
Husband, my lord.
yes.
He filed a petition under section 12(1), my lord.
Yes, seeking
seeking for a
annulment
decree of
marriage.
my lord, nullity of marriage
Mm.
on the ground that my lord, the respondent is an impotent.
Mm.
During the pendency of the proceedings, my lord, he filed an application seeking for a direction, direct the wife respondent to undergo for a medical test to prove that my lord, she is capable to get married.
Mm.
That was came to be rejected, my lord.
How
There are-
this memo is moved? What is the urgency for that?
My lord, he, my lord, got married in the year of 2015. Matter, my lord, was laid before the trial court for 9 years. She has filed, my lord, against me a domestic violence. She has also prosecuted me under 498.
You also filed this writ petition of 2023.
My lord, the application itself is rejected in the, my lord, 2023.
We will pass orders. Please come to the order.
Lordship may kindly see.
Yes. Now that
Please.
you will say that she is impotent
Please, my lord.
and you will send her to the medical test, and basing on that medical test, you will prove.
Please, my lord.
Yes. Please come to the order.
Lordship may kindly see.
Hmm.
The petitioner, my lord, is an husband.
Order impugned, where is it?
Please, my lord. Order, my lord, impugned. Annexure E, my lord, 2/2023, page number 55 to 71, my lord. 71. The finding, my lord, is, my lord, available in page number 70, para number 15, my lord. Only one para, my lord, that is the finding.
At what stage this application is filed?
My lord, it is, my lord, set down for evidence. Before the evidence, my lord, it is being
No,
filed.
no, it was filed in the inception, sir. 2016 itself has been filed.
Even before any.
Yes.
What is the date of marriage?
Date of marriage, my lord, 11/6/2015, my lord.
When did you file this MC?
5/8/2016, my lord.
Yes.
Lordship may kindly see. I just pass on few judgments. My lord.
Take that.
Request your lordship to
Yes.
go to first judgment, my lord. It is very clear, my lord, from the Supreme Court. It is held 2003-4 Supreme.
Para of 2003 judgment.
Please, my lord.
Sharadava Dharmapal.
Please, my lord. Para number, my lord, 76, my lord.
Para 76.
Please. May I read, my lord?
Yes.
Page number, running page number 31, my lord.
Yes.
The matter may be considered from another angle. In all such matrimonial cases where divorce is sought, say on the ground of impotency, schizophrenia, etc., normally without there being any medical examination, it would be difficult to arrive at a conclusion as to whether the allegation made by a spouse against the other spouse seeking divorce on such a ground is correct or not. In order to substantiate such allegation, the petitioner would always insist on medical examination. If the respondent avoids such medical examination on the ground that it violates his or her right to privacy, or for that matter, right to personal liberty as enshrined under Article 21 of the Constitution of India, then it may in most of such cases become impossible to arrive at a conclusion. It may render the very grounds on which divorce is permissible negatory. Therefore, when there is no right to privacy specifically conferred by Article 21 of the Constitution of India, and with extensive interpretation of the fair's personal liberty, this right has been read into Article 21. It cannot be treated as an absolute right. What is emphasized is that some limitations on the right have to be imposed on, particularly where two competing interests clash in matters of the aforesaid nature, where the legislature has conferred a right upon his spouse to seek divorce on such grounds.
Please come to para 78.
78, my lord. It is, however, axiomatic that a court shall not order a roving inquiry. It must have sufficient materials before it to enable it to exercise its discretion. Exercise of such discretion would be subject to the supervisory jurisdiction of the High Court in terms of Section 115 of the Code of Civil Procedure and Article 227 of the Constitution of India. Abuse of the discretionary power at the hands of a court is not expected. The court must arrive at a finding that the applicant has established a strong prima facie case before passing such an order. In this matter, my lord, there is no cohabitation at all. Since from the beginning, my lord, the respondent, my lord, not even allowed to take the respondent. The petitioner not even touched her. There is no ceremony. Even the ceremony is conducted, she was refused.
Yes.
From the beginning, the entire pleadings of the petition is very clear. That is the reason, my lord. That is the reason the petition, my lord, instituted for seeking for a decree of nullity for not divorce.
Understood. Yes, next.
Next, my lord. Next para, my lord.
Palani Swami.
17
I've seen
and
the judgment. I've read the judgment.
next. I may request
70.
the next para, my lord. The next para.
Yes.
Are the very same judgment. If despite an order passed by the court, a person refuses to submit himself to such medical examination, a strong case for drawing an adverse inference would be made out. Section 114 of Indian Evidence Act also enables a court.
First is you should make out a prima facie case.
Please, my lord.
Court should be satisfied
Please,
while
my lord.
exercising a jurisdiction of 115 or
Please,
227
my lord.
that you have made out a case.
Please, my lord.
Then the court will order for that.
Please,
If the other person refuses it,
Please.
then the question of adverse
Please, my lord.
inference. So now the whole question is, have you passed on those steps?
Please, my
The
lord.
question, at what time you have filed this application?
This application is being filed.
Just you file your case and immediately you file an application. Is it a case that there is you have already made out a prima facie case?
Lord, when a petition is being filed under Section 12, my lord, for seeking for nullity of marriage, my lord,
So
unless,
every-
my lord,
every
unless
person-
there is my lord, medical evidence, my lord, I can't prove my lord she is impotent. Because my lord, it is an arranged marriage. She is also stranger. My lord, marriage has taken place in the year of 2015 itself.
Yes.
My lord, there is no cohabitation at all between the parties. My lord, how, my lord, under what material, my lord, what can expect me to produce, my lord, before the court to demonstrate that, my lord, she is impotent or not impotent, my lord. Only, my lord, by way of medical evidence, it can be, my lord, examined.
Yes.
Next matter, my lord.
Palani Swami, which para?
My lord, this Palani Swami judgment, my lord, I have produced only for the reason, my lord, before the trial court, they have, my lord, raised an objection, saying that, my lord, there is no provision, my lord, seeking for a medical examination. And there is an error in the provision. That is the only reason, my lord, I have produced that, my lord. Even the error, my lord, can be neglected. That is
not
the only
necessary.
reason.
Yes, next judgment.
Next judgment, my lord.
Zahida Begum.
Zahida Begum.
Hmm.
Para number 3, 4 and 5, my lord. Married, my lord?
Yes,
Page number 48, running page 48, my lord.
yes.
I have been taken through the impugned order with the assistance of the learned counsel appearing for the petitioner. It is no doubt true that directing either of the parties to undergo medical test in the circumstances is certainly warranted. The question is whether the defendant should be subjected to medical test or the plaintiff also should be subjected to identical test. It is to be noted that the specific case made out by the plaintiff petitioner is that the marriage could not be consummated as the defendant respondent was impotent and he was unable to perform the matrimonial obligations. In the circumstances, the question whether the plaintiff petition is virgin or is not a wholly unnecessary. In the circumstances, the learned trial judge could not have directed the plaintiff petitioner to undergo virginity test at the hands of the so and so. The question whether right of privacy is invaded in the matrimonial case where the parties are subjected to medical test has been set.
Those judgments are referred to in this. The earlier judgments are referred to.
Even in the
Sharada's
order.
case and all
Even in the order, it has been reflected, my lord. All these judgments have been.
in this judgment.
Lord, the para number 5 is very clear in this order. The order directing the defendant respondent to undergo medical test at the hands of the heads of so and so Kim's Hubli regarding potency is maintained. The order directing plaintiff petitioner to undergo virginity test is on so and so is set aside. My lord, it is permissible.
Yeah.
Next, my lord. Shiva Dayal.
Not Shivadaya. Next is Madhya Pradesh High Court judgment.
Please, my lord. Shiva Dayal. Oh, sorry, I'm sorry, my lord.
Shantabai.
Shantabai, my lord. That is, my lord, page number, running page number 53, para number 6, my lord. On the bottom, last 2 lines.
Yes.
Whether it is found that after a reasonable time of marriage, there could be no copulation in spite of opportunity.
Are you reading para 6 or para 8?
6, my lord.
It starts with Srimati Shanti Bai.
And the last 2 lines, my lord.
After 1 month, she went back to her matrimonial home.
The basis on which, that is para number 5, my lord.
Para number?
That is in para number 10, out of that point number 6 in the last line. 53, last 2 lines.
The finding is at para number 11.
Please, my lord.
Applying these tests to the present case.
Before that, my lord, I would like to read, my lord, that point number 6 in page number 53, bottom of the 2 lines, right side corner. Last, my lord, 6 in bracket. Running page number 53, my lord. On the bottom right side, last 2 lines. May I read, my lord? Whether it is found that after a reasonable time of marriage, there could be no copulation in spite of opportunities because the other party refused to intercourse and resisted all attempts by the husband without just cause, the court would be right to conclude that the refusal arose from the incapacity to consummate the marriage.
I'm not able to find where are you reading. Are you reading this judgment of Madhya Pradesh AR 1966
Please, my
Madhya
lord.
Pradesh?
Please, my lord. That is, my lord.
Paras are very clear. Why this confusion?
My lord, para number 10, my lord. Page number 12, 53, 10.
Legal position on impotency.
The
is-
true
does
legal
not
position
install.
impotency is
Huh?
in the very same para, last bottom second line from the bottom.
Whether it is found that after
Please, my lord,
reasonable.
please,
Yes.
please, my lord.
No,
Whether
if
it
you
is-
say 6 in 10.10, the para number 10.
Point number
people
6 in
understand.
para number 10, my lord, please.
Yes.
Whether it is found that after a reasonable time of marriage, there could be no copulation in spite of opportunities because the other party refused to intercourse and resisted all attempts by the husband without just cause, the court would be right to conclude that the refusal arose from the incapacity to consummate the marriage. Applying these 11, my lord, I'm reading 11.
Yes.
Applying these tests to the present case, in having given our anxious consideration to all the facts and circumstances, we have come to the conclusion that although the appellant is not structurally or psychologically incapable of allowing sexual intercourse generally, yet she has an uncontrollable aversion to allowing the courts to the petition husband. This case belongs to a rare variety of frigidity, quad hank, and we further find that such unconquerable aversion to the consummation of marriage existed at the time of marriage and has been in existence continuously. We are satisfied that his proceedings have been free from collusion. The parties appeared before us.
No,
endeavor-
once you have a judgment of the apex court, then
Please.
why do you want to rely on the judgments?
Please, my lord.
Yes.
All the judgments are following the very same, my lord. My lord, my respectful submission before this Honorable court is, my lord, My lord, she was with me for very particular period of very short period. My lord, she never allowed me to touch her. And my lord, there is no cohabitation between the parties, my lord, according to me in my petition aversion. My lord, when such being the case, my lord, the husband cannot be expected to demonstrate or produce any document, prima facie document before the court to show that, my lord, she is impotent. Unless, my lord, there is a medical examination, my lord, by way of, my lord, order of the court, my lord, I can't demonstrate before the court. That is my grievance, my lord.
But the petition has been filed on 4/1/2016, man.
4/1,
2016.
he said 5/8/2016.
4/1/2016 was the date when the
That is after 6 months of marriage.
marriage.
Hmm.
So they had issued a notice to me on 26/12/2015.
26/12/2015.
Within 8 to 9 days, they filed the petition without even waiting for my reply to replying the notice. They filed the petition. Subsequently, the first week of January 2016, I filed the this reply notice. We issued the reply notice to their notice, which is dated 26/12/2015.
Reply is when?
So first week of January 2016. By
First
that
week
time,
means what is the date?
it is a 7th manner, 7/1/2016.
Ah.
They had filed the petition on 4/1/2016 itself. Now, my lord, the marriage has happened on taken place on 11/6/2015, my lord. 15, 11/6/2015. The first nuptial ceremony has happened on 20/11/2015. 20/11/2015. So subsequently, they started to live together, man, as husband and wife. For my submission, sir, the marriage has been consummated. First submission. The second submission is, my lord, this petitioner wanted a divorce, my lord. Since as per Act is not, there is a embargo that within 1 year you can't file petition. They filed this petition for nullity of the marriage. So kindly come to para 8 of the petition, my lord, which is at page number 30. Sorry, page 21, my lord. Para 8 of the petition before the trial court. We permit to read this one, my lord.
Yes.
The petition further submits
Yes.
that during her stay at his residence, the respondent on 5/12/2015 has taken to gynecologist Dr. Lata at Pragati Clinic, which is situated at Chikka Alessandra, Bangalore, for consultation. Even to the aforementioned doctor also, the respondent has not allowed her to test and to make preliminary inquiries. The doctor expressed that some counseling is necessary and detailed examination is required from the reputed doctors to test the maturity or otherwise health condition of the respondent. Now, kindly come to page 30, objection statement which the respondent has filed before the trial court. Para number 11. Be permitted to read this particular para. In that one, my lord, there is contrary around after 8 lines, my lord, in the middle of the paragraph. Contrary to the above, the petitioner had forcibly, by misleading and manhandling the respondent without any intimation to her parents or to anyone, had taken to the said doctor, who is not a gynecologist, but is just a physician without any specialization, and the said doctor tried to make physical examination against the wishes of the respondent as regards to her bodily composition or her femininity, and the said doctor forcibly conducted the examinations and had declared that the respondent is hale and healthy and has no health issues, and her femininity and bodily composition is normal as like any other woman, and the said doctor had never prescribed any medicine or counseling or further examination as alleged. The above clearly demonstrate the sadistic attitude, nature and character of the petitioner towards the respondent. My lord, there is a document in his custody, my lord. Till date, he has not produced the document and has not laid the evidence. He has to prima facie prove his case. Until unless that is proved, this application is premature and it cannot be considered.
Please come. Agreed with the orders passed and I number 4 in MC number 56 of 2016 dated by so and so, but dated 2nd February 2023. The husband is before this court. The husband had filed the number 56 of 2016. Seeking seeking to declare the marriage as nullity, as the wife is not a competent person to consummate the marriage. As per the averments of the petition that is filed, seeking nullity, seeking to declare the marriage as nullity. It is the case that the marriage has taken place on 11/6/2015. And after the marriage, the wife had came to the house of the husband and stayed for 1 day and immediately left her parents' house. It is the case of the husband that the wife had not shown any interest or affection towards the husband and the marriage is not consummated. Within a few days, the husband searched a rented house and informed the respondent to join the company of the husband. The wife and her parents put forth unnecessary conditions that the aged mother of the husband should not be with them. And the relatives of the husband should not come to the rented premises. So on and so forth, as a condition to join the matrimonial home. The respondent, the wife had not joined, and whenever he approaches the wife by going to her parents' house, she has not expressed any kind of interest in him and not allowing him to come near to her. The husband had made all his best efforts. It is his case that the wife is calling him during his office hours and abusing for the unknown reasons. It is stated that on 1/11/2015, there was mediation held at JP Nagar, the relative space of the husband, where the parents and the wife and her parents agreed to send her to the house of the husband. And it was also decided to perform the nuptials on 20/11/2015. A condition that they impose a condition that the relatives of the husband should not be attend the function. And a small function was held on 20/11/2015. According to him, there was no, the marriage could not be consummated. It is also stated that on 5/12/2015, he had taken her to a gynecologist, Dr. Lata, at Pragati Clinic, which is situated at Chikkala Sandra, Bangalore, for consultation. And even she has also not permitted the doctor to test her and make a preliminary inquiry. The doctor expressed that some counseling is necessary and detailed examination is required from the reputed doctors to test the maturity or otherwise health condition of the wife. It is also the case of the husband that the wife had developed a kind of insecure feelings and has become very suspicious and tried to test the patience of the husband in different ways. She was talking a lot about the character of the husband, defaming his self-respect. On 22/12/2015, the respondent and her parents came to the house of the wife along with her parents came to the house of the petitioner and started quarreling with him for unknown reasons. And the father of the wife also threatened him with dire consequences.
On the day the petitioner went to his house and found the same, is locked, and the wife had taken away all the household items, gold rings, silk sarees, and other items to her parents' house. It is stated that on these grounds, as there was no other alternative, he had issued a notice on 26/12/2015, calling upon the wife to give consent for dissolving the marriage. After receiving the notice, she lodged a complaint on 1/1/2016. And he has come up with the present petition taking to declare the marriage as nullity. The wife had filed her objections to this petition, and she has denied the allegations. And according to the wife, the marriage is consummated. It is stated that the husband had forcibly, by misleading and manhandling the wife without any intimation to her parents or to anyone, had taken to the to Dr. Lata. But who is not a gynecologist, but is just a physician without any specialization. And the doctor tried to make physical examination. It is the wishes of the wife as regards to her bodily composition and her femininity. And the said doctor forcibly conducted the examination and had declared that the wife is hale and healthy and has no health issues. And her femininity and bodily composition is normal, as like any other woman. And the said doctor had never prescribed any medicine or counseling or further examination. In view of the same, it demonstrates the statistic nature and character of the husband. And along with that, she has taken a stand about the consummation of the marriage and that the petition has to be dismissed. This application, that is I number 4 is filed. Which is the date of the application?
24/11/2016, my lord.
On 24/11/2016, IA number 4 is filed. Seeking a direction to the respondent to appear before the competent doctor or gynecologist for medical examination about a physical, psychological capability in consummation of marriage and furnish the report to the court. The trial court, by order impugned, had dismissed the application. The court, while dismissing the application, had observed that the court had relied on a judgment of this court in Regamma versus Shantappa. And observed that in a case where a party alleges that a person is impotent or suffering from other such incurable disease, it is for a person making such an allegation to prove the same. A party cannot be compelled to undergo medical examination. It is also observed that there is no provision in the Hindu Marriage Act or the rules framed thereunder, or in the Code of Civil Procedure, or in the Evidence Act, or any other law which would show any person in the court to compel any party to undergo medical examination. And the court had also considered the judgment of the High Court of Andhra Pradesh in case of Pulavati Sriram Murthy versus Lakshmi Kantamma. And relying on these judgments, the court observed that the marriage of the petition, the marriage is solemnized on 10/6/2015. And according to the petitioner, nuptial ceremony was arranged in the month of November. And at para number 8, the office of pleadings had taken contention that during during the stay of the wife in his residence on 5/12/2015, he has taken to the gynecologist. He had not produced any document to that effect to show that whether there any advice is given to the respondent. Dr. Lata is gynecologist, and the wife, the husband himself had taken the wife to the hospital. Therefore, question of issuance of direction to the wife for medical examination do not arise. When the husband has approached the court seeking the declaration that the marriage is a nullity, he has to prove the facts. Therefore, without evidence for both the parties, application filed by the husband is not maintainable, and accordingly dismiss the application. Agreed thereby, the present appeal is filed. And counsel for the petitioner submits that the marriage could not be consummated as the wife is impotent. He has no other way to prove the case except sending the wife for medical examination. Unless and until she is examined and a report is placed before the court, it is difficult for the husband to prove his case. And the trial court, without considering all these aspects, had dismissed the petition. He had relied on the judgment of the apex court in case of Sharada versus Dharmpal, reported in 2003 for SCC 493. He relied on para numbers 76, 78, and 79, which reads thus. Extract all this paragraph. He had also relied on the other judgments of the other high courts, which were passed, taking into consideration. They're all laid down by the apex court in Sharada versus Dharampal's case. Relying on the said judgment, he submits that the finding of the court is contrary to the certain law, and sending her to a medical examination is not a violative of Article 21 of the Constitution of India. And court had failed to appreciate the contentions put forth and the legal position, and as envisaged by the Honorable Apex Court. That's it.
Please, one more submission, my lord. Whatever the judgment, my lord, relied upon by the trial court, is, my lord, in the Dharmapal's case, my lord, everything is discussed.
Submits that.
And, my lord, it is
The judgments
reversed.
that are relied on by the trial court are all considered by the apex court in Sharada versus
Please.
Dharmpal's case. And the court ought to have considered the said judgment. Next, learned counsel appearing for the respondent wife submits that the marriage had taken place on 11/6/2015. And the nuptial ceremony was held on 20/11/2015. The marriage is consummated. When a notice was issued on 26/12/2015, they have issued a reply notice on 7/1/2016. Even before the reply is sent, they have filed the petition on 4/1/2016. It is a case of the husband that, it is a case of the wife that the husband wanted a divorce, and as they cannot move an application for divorce before 1 year from the date of marriage, he has come up with this application. The learned counsel submits that when according to the husband, he had taken the wife to a doctor by name Lata, a gynecologist, and the wife has been subjected to the examination. In the evidence, he could examine the said doctor, and he can also place before the court the report of the said doctor, as even the wife is admitting in her pleadings that the husband had taken her to the doctor. Learned counsel submits that without making any effort or without even discharging the burden on him
he cannot file an application straight away for subjecting the respondent to the medical examination. It is submitted that the judgment of the apex court, which he is relying on in Sharda versus Dharampal, in fact supports the case of the wife, and the trial court had rightly dismissed the petition, and no grounds are made out seeking interference with the well-considered order passed by the trial court. Next paragraph. Having heard the counsels on either side, there is the material on record. The marriage had taken place on 11/6/2015, and he had filed the application, that is the present MC petition, on 4/1/2016. According to the husband, the marriage is not consummated as the wife is impotent. He has made all his efforts, and it is also his case that he has taken the wife to a gynecologist by name Lata. Even the same was accepted and affirmed by the wife in her objections, stating that she has been taken to the doctor. And according to her, the doctor had, after examination, has felt that by all means, the wife is normal. The husband had not adduced any other evidence, the evidence of the family members or the relatives, or he is also referring in his petition about the mediation that is done. Now, unless and until he makes out a prima facie case wherein with the available evidence that because the wife is reluctant, and in that regard, the mediations were also done. And having no other go, he had to come before the court with an application, with this petition seeking nullity of the marriage. Straight away, he cannot come up with an application stating that the wife has to be subjected to the medical examination. The Honorable Apex Court in Sharda versus Dharampal's case had considered the rights of a party and their right to privacy under Article 21, and also the court the right to privacy as enshrined under Article 21 of the Constitution, and also and how it has to be balanced with the right of a person to defend himself. The court had observed that when there is no right to privacy specifically conferred by Article 21 of the Constitution of India, and with the extensive interpretation of the phrase personal liberty, this right has been read into Article 21. It cannot be treated as an absolute right. What is emphasized is that some limitation on this right have to be imposed, and particularly where two compelling interests clash in matters of the aforesaid nature, where the legislature has conferred a right upon his spouse to seek divorce on such grounds, it would be the right of that spouse which comes in conflict with the so-called right to privacy of one party. There, the Apex Court has felt that there should be a balance between a right to privacy and at the same time the right of the other person to be adequately defend himself. Then while laying such a ratio, the Apex Court has also categorically observed that in those cases, the court shall not order for a roving inquiry. It must have sufficient material before it to enable it to exercise its discretion. And such discretion would be subject to the supervisory jurisdiction of the High Court in terms of Section 115 and of Article 227 of the Constitution of India. Abuse of the discretionary power at the hands of a court is not expected. The court must arrive at a finding that the applicant has established a strong prima facie case before passing such an order. For applying the ratio laid down in honorable on the judgment of the apex court in Sharda's case, the first and the foremost is the party who seeks such a relief should make out a prima facie case. In this case, what all, yes, it is, now it appears that it's a case of the petitioner that whatever the averments that that is stated in the petition is a prima facie case. In those averments itself, he has stated about the mediation that had taken place. He taking the wife to a doctor. He should put forth his case that by choosing necessary evidence that I'm under, he should make out a prima facie case in that. And in those circumstances, still, if the medical examination is required, and if the court comes to the conclusion that unless and until a medical examination is conducted, the petitioner husband would not be able to prove his case. And having satisfied that there is a prima facie case, then at that stage, either the application or the request that is made by the petitioner for examination can be considered, but it cannot be at a threshold without even adducing any evidence or without even making a prima facie case, a strong prima facie case, where the court will be compelled to ask the respondent to subject herself to the examination. In the considered opinion of this court, the stage at which the application is filed by the husband is not appropriate, and as on the while and you could not make out a strong prima facie case, which can compel the court to pass an order subjecting the respondent to medical examination. In that view of the matter, this court finds no reason to interfere. But however, the liberty is given to the petitioner to file such an application at an appropriate stage.
Number 7, Monisha NS.
Accordingly disposed of.
Monisha NS for petitioner,
rest.
Ravi A. Belagatti.
For the
Here for
respondent, I
petition.
filed my NOC Vakalat.
Matter may be kindly refer to mediation, my lord.
Matter may be referred to mediation.
Both the parties submit, both the counsel submits that the matter may be referred to the mediation. When will you appear?
21st, before the
21st. 21st is a Saturday.
They wanted us Saturday.
20th?
Because both of them are working members.
But some star is there on the 21st, no? It's working Saturday?
It is a working Saturday, even for the High Court, it's.
Yes, this 21st is a working.
Bangalore mediation.
For both the parties, it is submitted, both the advocate submits that there is scope for settlement. Both the parties shall appear before the Bangalore Mediation Center on 21st
At
at
11.
at 11 o'clock. The registrar judicial shall communicate with the same. Yes.
Cell number 8, adjourned. Cell number 9, Madiwal Jagdish, Bhimappa, Rashmi George for respondent.
For the petitioner, my lords. While order dated 30th of July, my lords had passed an order directing the petitioner to pay arrears of maintenance at the rate 30,000. What is challenged is 50,000. What is granted and what is challenged is 50,000. I have got a DD, my lords. It's not the entire amount, 3 lakh amount DD. This is what I've brought, my lords. I'm just handing it.
3 lakh?
3 lakh, it's the DD amount.
Lord, it was told to pay at least 2/3 of the total maintenance arrears.
Where is the order?
It is already.
Order dated, so that the court will have a look at and understand what is the order.
July 13.
30,000 per month as arrears.
Yes,
So
ma'am.
how much it would come to?
That's from the date of the petition is what my lords had stated. It would come up to 9,70,000 from the date of the original application.
9,70,000.
Yes, ma'am.
Now, today you are paying how much?
3 lakh, my lords.
3 lakhs.
Yes, ma'am.
What you paid earlier? You have not paid anything. right
Nothing.
now.
Not
50
even one penny, my lords.
50,000 was paid in the interim, my lords. The respondent had filed an execution petition where a warrant was issued.
50,000 you have paid.
Yes, ma'am. Yes, ma'am.
Even this amount is after reducing from 50 to 30,000.
My lords, I must submit. It is 10,20,000. What is pending is 9,70,000, out of which 3 lakh is what I've got today. That 50,000 I had already deducted and then submitted, my lords.
So, no, at 30,000, you are saying what is the total amount?
10,20,000 from the date of application.
10,20,000.
At
You paid
30,000.
how much?
50,000.
Plus now you are paying 3 lakhs.
Plus I've got a DD for 3 lakh.
50,000.
Yes, ma'am.
What is due now?
The remaining amount, my lords, of 6 lakh.
Should be more than that. 6 lakhs.
Yes, ma'am.
When you will pay that?
That will take some time, my lords, because he's unable to pay maintenance. That's exactly why he has challenged the order before my lords here.
So this is what you agreed. That day when the
I
matter
completely
came up.
understand, my lords. It was an order passed. I will pay. It is my duty as a husband. It is my duty to pay the maintenance. I'm not going back on that. But then not in the not at one go. He's unable to pay.
Has to wait for it.
My lords, he's unable to pay, my lords. That is, he has assailed the order on that ground, my lords. My lords, another submission, my lords. Kindly see the assets and liabilities of the respondent, my lords, at page 16. He's a music teacher, my lords. It has already been recorded, my lords.
Is it the case where he's working in Dubai and all?
Yes, my lords. Yes, he was working there and then he lost his job. Now he's a freelance music teacher there.
How much he's getting as a music?
Around 90,000, my lords. It's not a fixed salary which he's getting because of the music teaching. It depends on the students. Yes.
My lords, he has
No. Like maintenance is only to the wife or the children only?
wife
Both
and the
men.
children, wife and 2 children. My lords. He had left her in 2021. He was very cruel to her. He was beating her and hitting her. She had to leave her job in Dubai and had to take asylum with her father, who is a priest in one church. And he never took care of her from that day till today. And she is doing overnight shifts in one company and taking care of 2 children who are of the age of 11 and 13.
No, right from 2021 till now, how do you expect that, Mr. Counsel?
Yes.
How do you expect that she'll take care of 2 children and you live somewhere?
My lords,
My
I bow down to that. I'm getting the DD. I've instructed my clients. I've instructed.
Report from 2021, why he did not pay anything for the children? If not 50,000, something should have been paid. Who will take
That's-
care of the children?
My lords, I bow down to that. I bow down to that. I've instructed my client. He'll comply with the order, my lords. But then 50,000 is he's unable to do it at a go, my lords. He will do it, my lords.
Why 30,000 is not able to do?
My lords, not at one go, my lords. I understand, my lords. It's the arrears which have piled up over a period of time. He'll require some time to do it, my lords.
He's earning 90,000 from when?
My lords, from last May, my lords.
So it's more than a year.
My lords, I must submit.
Please understand.
He's
for
paying
sure.
30,000 as EMI on house loan, my lords.
Please wait. So you earn 90,000 from the last more than, let May, June, July, August, September. That is from the last
15
16
months.
months.
Yes, ma'am.
16 months you are earning 90,000 and you happily enjoying, not even giving one
My lords,
paise to your
he's
children.
paying his home EMI, my lords. He's also paying that. He's also taking off his
His home
ailing-
EMI 30,000.
ailing mother
Still
also.
60,000. What is he doing with it?
Ailing mother also, my lords, and he's also staying in a rented residence there in Dubai.
Support the children. That's not the argument. Please don't.
That
argue
I
like
understand, my
that.
lords.
Those are not the reasons, sir.
That I understand, my lords. I completely bow down.
About the quantum, whether it is 20,000, 30,000, 10,000, but he has an obligation. What is he thinking that, how the children, how they will get on with life?
I completely
What is the
understand.
age?
The age of the children are 11 and 13, my lords. They are studying in a good school and she is supporting the children and she does not have a house.
No, if you tell the court, you pay some amount and say that I can only pay this. No. Court granted 50,000, then this court said, no, you pay at least 30,000. For 30,000, you ask for time, and some peanuts you give the 3 lakhs and say that, I can understand you paid 6 lakhs, 7 lakhs, and said for 3 lakhs, you're asking time.
Lords, I completely bow down on that, my lords. He's not
That is
financially,
sufficient.
he's not financially sound as on this day to make any payments, my lords. If my lords recollect, it was posted on 21st of August. He was unable to get, he was only able to manage to get.
It's paying every month. Now,
My lords,
apart from all this.
as of now, he has not paid, my lords. I have instructed him to pay 30,000 per month from this month onwards, because he said he could only manage to get 30,000, 3 lakh DD. I have instructed him to.
Do one thing, we can't compel him anything to pay here. We will pass orders on this. 50,000 we will confirm. Let them go for execution. Then the law will take its own course.
My lords, I have challenged the order.
We'll hear you and pass orders. And let him, because court has given him a very long rope. If he's not understanding, we can't help it. No, why should this be pending?
My lords may not confirm it, my lords, because I would also want to point out on merits that apart, my lords, before going there, my lords, I have a DD of 3 lakh for today, my lords. Some more time is granted, he'll manage to, he'll have some breathing space to get some money, he'll have some.
It's an indefinite period, manage. There should be some definite period for that when you will do it.
Lords, as of now, he is not in a financial position to pay.
That's why we'll hear it on the merits of it.
Very well.
And we'll pass an order. Let the execution go on.
Well.
Yes, please, Arvind. Give it to her.
It may be recorded.
Yes, I'll record. Yes, Arvind.
Kindly have paid 69 for a moment, my lords. I'll directly take my lords to the assets and liabilities, what she has.
No, we'll go to the interim or the order, or impugned order first.
Very well. Page number 98 to 117, my lords, annexure G.
Who filed the MC? Wife had filed the MC.
Yes.
What are these 2, 3, and 6? You sought interim maintenance of 98,000.
One was for the visitation rights. and-
IA number 3 is filed for interim custody of the children. IA number 6.
Blocked access to minor children.
So you're only questioning before this court, IA number 2.
My main grievance is that, man.
IA number 2.
Yes.
So where is the finding? So the petition sworn in para number 4, please come to that. Her monthly salary is 63,360. A person with 63,360 will maintain 2 children under herself. And a person with 90,000, he can't even give 10 rupees to his children.
I'm not on that, my lords. I completely bow down to that, my lords. He has not paid his.
It shows the conduct of your client.
I understand.
It shows the conduct.
I understand,
And
my lords. I've
whatever-
instructed.
At least had it sent 10,000 rupees to the children for their necessities, though the court could have understood that he has some difficulties. You can pay 30,000 for your AMI, not even 10,000 for your children.
His housing, my lords, but anyway. Page number 113, my lords, para number 12, 113. That deals with point number 1. In page number 112, points for consideration is framed. The first one is with regard to IA number 2 for the maintenance.
Yes.
The petitioner sought 98,000 per month for interim maintenance and for education of children. She contended that she is taking monthly salary of 61 odd, therefore sought for maintenance from the respondent for educational expenses of the child as well as maintenance for them. With the support of her claim, petitioner has filed affidavit regarding assets and liabilities. She has also shown the details of.
Come to India.
My lords,
When you lost your job.
I have not come back to India, my lords. I'm still there.
So when you lost your job?
My lords, that I have placed, it was a labor dispute. And then it was in
So this,
2021.
when is this MC filed? MC is filed in
2021.
2021. When is this IA filed?
19th of November 2021.
Along with the petition, my lords.
It's on,
16/11/2021, along with the MC petition, the IA was.
this is IA number?
Two.
To IA number 2. So what about his job details?
My lords,
What about his the details you're saying about when he, what about that labor dispute? Because the labor dispute, when he lost his job, before losing that, what was his salary?
my lords, before losing, I am unaware of the salary, my lords, because
That is
that,
also important.
I understand, my lords, it was
He
over
lost his salary, when he lost his job.
last year. my lords.
So from what is happening in 21 and 22 is relevant. And what is his salary in 21, 22 is also relevant.
Yes.
Now, what are you submitting is from 23 May, it is 90,000 is his salary.
My lords, there was a labor dispute which began in Dubai courts. He himself had to withdraw the labor
I
complaint,
want to know.
but then he did not get the interim, I mean, during the period of that case, he did not receive the entire salary. On
That
that,
particulars also we need to know.
that
for past
particulars, I don't have.
Place before the court. The petitioner shall file before this. Shall place
Milords, already he has not filed his assets and liability affidavit in the family court. Whereas he has filed his assets and liability affidavit in the domestic violence case, which I have placed along with my.
Say, sir.
It is along with my objections. In my
Page number
objections,
12.
Page number
12.
12. Milords, according to Rajneesh versus Neha, a person who does not file his assets and liability affidavit, I have my citation.
It's here and let's
Not,
see.
yes,
No,
mi-
please point out.
yes,
what
my
were the
lords, in
assets.
page number 12, he
Hmm.
has filed his assets and liability affidavit, which I have produced in this honorable. Milords, here he says his general monthly expense is
What is
80,000.
the nine, yes.
He says his general monthly expense is 80,000. And on the next page, page number 13, he says the approximate expenses incurred on account of the dependent, that is the mother age 20 years, is 20,000.
Where do you get that? Huh.
Page number 13.
Hmm.
And column number C 3,
Hmm.
20,000.
Hmm.
In page number 40, next page, he's admitting that he has one daughter and son, aged 13 years and 11 years.
Hmm.
And next page, in page number 15, Milords, saying that he is earning a monthly income of 1,20,000.
It is, when is filed, which
This
date
is
is
filed
that?
on March 2023.
That is with regard to the previous employment, stall sale
Milords,
executive.
24. Milords, March 2024. 23 March.
Nobody,
2024.
when you are filing your statement of assets and liabilities, you will mention what was it as on that
That is
date.
there in the
Let's
next
see the
page,
next one.
Milords,
So,
page 18.
Milords,
let's read it. Let's continue to read it. Where did you say so?
My lords, page 15 itself, F, name of the employer, Global Standardization Partner Project Management.
He terminated on 10th October 2021.
I am not working presently. And the next one, designation, in the bracket, he writes stall sale executive. That was his position, what he was holding there in that company, where he was getting paid 1,20,000. Further, my lords, at page 18,
there itself.
So
is-
according to him, company terminated him on 10th October 2021.
Yes,
You
Milords,
filed the petition on 16/11/2021.
2020.
So according to him, by the date he filed the petition, you filed the petition, he is no more in service.
Milords, he files a child custody petition on 25. On 27/5/2022, he is filing a child custody petition. And in that petition, he says that in page number, I have produced the petition along with my objections. Milords. Milords, in page number 20. That is his child custody petition in my, along with my objections. In that paragraph 15, Milords. This petition is filed on 27/5/2022. wherein paragraph number 15 on page number 23.
This
He
is
says
dated 27/5/20.
27/5/2022. There in paragraph 15, page number 23. The husband is telling he is working at Dubai and earning good salary to take care of both the minors. And custody of the minors has remained with the respondent. Here he agrees that he is working and he is earning good salary, which has been mentioned in the order which has been passed on IA number 2, Milords. Milords in
What
the.
are this, why this contradictory statements?
Lords, even as on this day, he is not running away from his responsibility. He will still
No,
take
please
care of
answer
his.
To the query, simple question.
Yes, ma'am.
You have said that when you file the statement of assets and liabilities, you say you are not working from 2021. That is December 2021. Then you will file a petition in GNWC. You were on 27/5/2022. You say that
Kindly-
you're earning a handsome salary.
Kindly have page 18 minutes of the very respondent's or statement of objections. Page number 18. I have told details of my current employment. I have, which says 91,000.
So according to you, with that 91,000, you can take care of your children. You want a custody of the children. So why don't you pay the maintenance now?
My lords, he will.
It's not only 91.
It's high time that your client understand that in every, whatever, in GNWC, I'll take one stand. When it is maintenance, I'll take the other stand. No.
I bow down to that, my lords.
And then, no, it's not about it. Now we'll ask the court to initiate perjury proceedings against him for these kind of statements made before the court.
My lords, here in page number, in the GNWC, he has not disclosed that how much he is earning. He is earning a good salary. It may be subjective. I will take care of my child.
When you have to pay maintenance, I have no job. I'm fighting the labor problem. I cannot pay. I am that in this. When it comes
My lords,
to
I have challenged the quantum of maintenance that is ordered. I am not absolving myself from paying.
Why are you not paying?
My lords, I have instructed him to pay from now on at least so that his burden, his burden reduces. But then he is not absolving from his liability. He will pay the maintenance. As of now, he is in a financial crunch and he is unable to pay the entire amount at one go, my lords. That's his problem. That's the only.
Sort of us.
My lords, July 2023, my lords.
July 2023. What was the interim order by this court?
No interim orders, my lords. We have challenged it much later in 2024, January 2024. And there's no interim order.
Why are you not paying from 2023?
My lords, he's
Monthly maintenance.
that I agree, my lords, that I have instructed my client to at least start paying from now, my lords. I may not have anything more to say
Tell
on
your
that.
client what is that? If he pays by September 30th, he shall pay the remaining amount.
Milords, it's not only the
Lords,
amount. It is
September
not only
30th is-
that amount, they are mentioning two salaries here. One, they say they are earning 1,20,000 from the music business. And another one, he is having 91,000 AEDs. And there is two income which amounts to 2,11,000 per month he is earning. They are telling in the DV assets and liability affidavit, they have filed it in the DV petition. Now coming to the family court, at the same time, here the matter was being heard and he was not kind enough to file the assets and liability in the family court. And according to Neha and Rajneesh,
No, all these things you have stated so in your objections at one go.
Yes, my lords.
Where is it? Please come to that.
That is in the assets and liability affidavit.
Not that. You have filed an affidavit before the court.
I have.
Your objections you have filed.
Objections, yes,
In
ma'am.
that objections, have you summarized all
Yes,
this?
yes, ma'am.
Where is that?
Yes, ma'am.
Page number 6, my lords.
Have you filed your reply to this?
Yes, ma'am.
No, my lords, I have not filed my reply to
necessary.
this.
Yes,
My
my
lords.
lords, in page number 5 onwards.
My lords, what is stated here is 2,11,000 per month, which is
Yes, my
not
lords,
on
in page
record.
number
The
6.
records itself are clear. It is not 2,11,000, my
It's
lords.
very clear,
That's-
my
that's-
lords, he's saying from the music classes, he is earning 1,20,000.
Please come to the.
And as an employer,
Page number.
in the assets and liability affidavit, page number 15. Page number 15,
What I found
F3.
is 1,20,000.
1,20,000. Presently, I'm taking music classes. It's not a salary. And in page number 18, he says details of the current employment. That was music
One minute.
classes.
Page number?
Page number 18. It is 4150 AED, rupees 91,000. It is the salary he is taking from the employment, not the music class. Music class is his hobby. He's a musician. He's taking it separately for the children. And he's getting
please
1,20,000.
Tell the court, what is this 1,20,000? What is this for 91,000?
My lords, I am told this 1,20,000 was his previous salary as stall sale executive, what he was earning. I understand that he has written it here as 1,20,000 and the next page as 91,000, what he was earning from his music classes. That's the discrepancy here. 1,20,000, as my lords can see in the column number 2, F2, stall sale executive is written as in paragraph.
As on that day, you're not
Yes.
working.
Yes,
Why did
yes,
you
my
mention
lords.
that my monthly income is 1,20,000?
My lords, the stall sale executive, what he has written up in the bracket and the subsequent column where he says that I was working and then I've lost my job. It relates to that, my lords. At page number 18, he has clearly told what he is getting now, approximately as a music teacher.
He has not told so, my lords. It is filed in a different case, in domestic violence case.
But
We
it's
are
still my
taking-
statement, my
And
lords.
here, nobody has said that it is, I lost the job or something. He has never stated in this. He is saying, presently I'm taking music classes and monthly income is 1,20,000. And now they are trying to concord the manner they want it. And now here he is saying current employment and latest income is 4150 AED. My lords, I have filed the objection he has, they only, the petitioner, the husband here, has filed his objection in their main petition on page number 55, my lords. It is an objection they filed for the IA we had filed under section 3 for the maintenance, in which he says that he is not objecting and he is not stating anywhere. This is filed on 26/11/2022, my lords. Here nowhere he says that he lost his job and he is not working. My lords, kindly peruse page number 55 of their main petition. Now they are trying to concoct a different story not to pay maintenance and escape from all liabilities, my lords. Page number 55 of the main petition.
Forty?
55 minutes. Here, this is the objection they have filed to IA number 2, my lords. There is nothing like he has no job, he has lost job and he cannot maintain the children, the wife and the children, nowhere it is there. His grievance is only that petitioner and her family members are greedy and money-minded, and the petitioner has left the matrimonial home with children, and the petitioner has blocked all access to the minor children, and the respondent further submitted.
Now he's
as per the
exercising the
order.
registration.
My lords.
Now he's exercising the registration.
She was ready and the children are not letting to go, and finally she brought the children to the honorable court also. The honorable court told the children to spend some time with the father and not to have any influence. Everybody left the children along with the father in the open court, and later also they came and met the children, and later the children only made submission in the honorable court. We don't want to go with him. He wanted to take the children to Dubai. And my lords, in the main petition, there is an allegation from the side of the petitioner that he is with another lady living in Dubai and with one children of him whose name is.
That's sub judice. That's
No.
their allegation. That is their allegation.
They are not objecting
That
to
is their allegation. Evidence is yet to be recorded.
Objections to our
Evidence
main
is yet to be
petition.
recorded.
In our main petition, our allegation from 24 till the end, they have not objected to that, where all these things are there. And here, he is with a lady in Dubai, he is living in their residence in Dubai, and he is having a daughter also in them, and the school certificates of the daughter with his name as the father and the insurance he has taken, everything is produced in the honorable court. And the children was seeing all these harassments happening and the hitting the mother and the problems happening on the name of that lady in their house in Dubai. And the children was brought, and without the mother, the petitioner is wife is present in this honorable court. She left the children with him. Children was not ready, but children was talking with him. Children talked with him for nearly 1 hour in the open court, my lords. But the children was not willing to go with him. He wanted to take the children to Dubai. And he was telling that he has a house somewhere here and he will take them there. But he produced a large receipt from where he had vacated. And even there also he wanted to mislead the honorable court by giving a hotel bill, which he had vacated 3 days back, and he wanted to take the children away. And these are the
No,
things
these are
happening
all-
during the visitation
These are all
arguments.
things which are sub judice.
They're all the things about your conduct of your client,
Context of the,
not nothing that the court will pass any order. She's only trying to submit.
this is a
What is the
context.
conduct of the father, obviously being how responsible he is towards his children. That's what she's trying to say.
Yes, my lords. Here, he doesn't show any intention to take care of the children, only to put pressure on the wife respondent here, that she will withdraw her cases. There is a case filed against him for bigamy also, and multiple marriage also. And he wants her to
Why you have
withdraw.
not filed execution when there is no stay?
Already it is filed, my lords, and there is a warrant also. There is a warrant for attachment of the properties. And it is then.
Which
they are
was
coming to the
recalled,
honorable
which was
court and
recalled.
yesterday. And then the honorable court insisted them to file some amount. Then they are paying 50,000 in the treasury and they are recalling the warrant. And then they are vanishing from there. Thereafter, they are not paying anything. And this is how he is trying to evade. And he does not want the execution case to go on now. They are saying the matter is in the High Court. Unless the High Court decides, we will not be paying anything. Execution case is happening there. They recall the warrant also. And the wife does not know any of the properties belonging to him in Kerala. And she says that he does not have anything in Kerala, or maybe he must have transferred to his mother's name or brother's name. And she has no idea where is it. And he is not coming after the warrant has been ordered. He is not coming. Now they recall the warrant by paying 50,000 rupees. That is the 50,000 they are saying that they paid maintenance. And it has come only recently to her account. Apart from that, he is not doing anything. And he is not even contesting his case also properly, my lords. He has not filed his assets and liability affidavit also. She is not even able to go abroad also for better job prospectus because of the cases happening here. He wants.
I have
pressure
not
on
initiated,
so
I have
that
not
she
initiated
takes
any
up all the
cases there, my
cases.
lords, against
They
her.
did all the divorce amicably without even 1 rupee being given. There was mediation talks where also he was telling, I cannot pay anything. You take the children away. That was his condition. You can take both the children. I will take back my GNW and you go
These
away.
statements are
He
all
wants the
disputed,
wife
my
to
lords.
mutually
These
give a divorce,
statements.
and he will give the children. But he does not want any responsibility. He does not want to take care of the wife. He does not want to take care of the children, my lords. She is suffering. She is paying this month's, this year school fees also she paid by borrowing money from others. She is living in the church accommodation, my lords. In his own affidavit, he is stating that he is aware that she is living in the church. My lords, in page number 18 of his affidavit he filed in the DB court, he says that free accommodation by the church in the column, whether she is staying in his or her own accommodation. He is stating free accommodation by the church. He is well aware that she is living, and for how long she can live in a church freely with the children. The church do not allow them. She wants to take a house for rent. She wants to give them good education. And he says he has a lot of expenses. He wants to spend 80K on himself and 20K on the mother. He has to pay 30K on the housing loan. And after that, everything is over and he does not have to give the wife and the children. And my lords, hence the Honorable Trial Court, my humble submission, Honorable High Court correctly ordered 50,000, but not even 1 rupee has come so far to our account or apart from the check he has given today. And my humble submission is that the 50K must be, the order may be upheld. And his defense may be struck down if he does not pay, my lords. At least the cases will get over. And he can seek for better job, at least he can take care of the children and he may be ordered.
By striking off his defense, nothing will happen to him because he wants
He will vanish.
He wants to leave you and your
In spite of
children.
being on bail, he is living. He has a bail condition that he should not live in India, my lords. And he is living
Should
in
not?
Dubai. He is on bail. There is an FIR against him. And the proceedings are underway. The trial is happening and it is for her evidence. And each time he is not coming, and so the public prosecutor is saying like, let him come and then we will lead the evidence. And he is permanently staying in Dubai, and there were so many NBWs against him, but he is not planning to come. And he is
Lords, with
living
regard
there.
to this criminal trial,
NBWs.
NBW was.
Are they pending now?
they recalled, last time they recalled, so I think that he will be.
My lords,
coming.
with regard
He
to
will be-
this criminal case, I am unaware, my lords, I'll have to seek instructions. With regard to this, I will have to seek instructions, my lords, because I'll have to dispute this.
He doesn't contest. Whenever there is an NPW, whenever there is a warrant in any execution case or in any CC, the lawyers will come, cite some reason and recall. And then he doesn't come back. Even in this honorable court also, in spite of, he wanted to stay, till today he is not present in this honorable court.
He
will
didn't
not
come
be
to the
present.
court today.
My
Your
lords?
client is not present in the court today.
No, my lords,
Right?
he's
First day
he's
is
not.
not. He will not come. He will come only when there is a.
I am representing
recall.
him through, I mean, he's handed over the wakalat minutes. He had come over when he had to hand over the wakalat minutes.
So happily he'll live in Dubai.
No, it's
He's
Going all,
Dubai.
no, he'll pursue the matters in India. He will be happy in Dubai, leaving the children and leaving the wife and children to live in a church premises.
that's not that. My lords, with all due
We'll dismiss
respect,
this petition with exemplary cause.
lords, with all due respect,
Conduct of the
Below.
husband and the kind of petitions he has filed, one after the other, and what the kind of stance he have taken in one petition to the other. Please understand, I'll post this matter next week. By the time he has to pay at least, what was the outstanding?
my lords, we have
It's
paid
more
3
than
lakh
15
50.
lakhs, my lords.
Ah,
I
then
have
3
to
lakh
calculate. It's
50.
more than 15 lakhs. Kindly the 50K may
No,
be
no, if it
upfront.
is at 30, it is 10 lakhs.
10, it is
10
10
lakhs.
lakhs.
10 lakh
So let's
20,000.
let him pay the remaining 7 lakhs by next week. Or else I'll dismiss this petition with exemplary cause, and also I'll direct the court to initiate perjury proceedings, looking at the manner in which he has filed the affidavits. Please communicate it to the client.
My lords, at least 2 weeks time, my lords, because he's, from what he has told, my lords, he is not in a position to borrow or something, my lords.
My
Kindly
lords,
give 2
why
weeks time at
it's
least so
not-
that he has some.
I understand.
Yes, ma'am.
Ultimately, it's for your client.
Yes, ma'am.
Yes. Pose this matter on. Pose this matter on 24th. By the time at rupees 30,000 per month, the arrears shall, yes, today, the petition, counsel of the petition has handed over a check of rupees 3 lakhs.
DD, my lords. Demand
A
draft.
DD of rupees 3 lakhs, the counsel appearing for the wife. It appears that he has paid an amount of rupees 50,000 in the execution. And the remaining amount calculating 30,000 per month from the date of petition till this month, till September 5th. The entire arrears shall be cleared and the amount shall be paid by 24th of September. If by that day, by 24th of September, if the amount is not paid, appropriate orders will be passed. Land counsel appearing for the respondent has pointed, respondent mother has pointed out that how the husband had taken different stands before the domestic violence court, before in a petition for maintenance, in a GNWC, in the proceedings, in a GNWC. Considering all this and this, and the stand of the husband and the affidavits that are filed, the appropriate orders will be passed on 24th.
Cell number 10. Nataraj BS, for petitioner. Venkata Chalapati, for respondent.
Yes.
My lord, it's husband petition in respect of interim maintenance on IA number 2, please.
How much is granted?
My lord, 5,000 is being granted.
What is your income?
My lord, I've been told that my income is around 25,000 per month as I work in a private factory.
So why 5,000 should not be granted?
My lord, she is working, please, my lord, in a.
Where is the evidence? Let's
My lord,
please
the
go to the order.
document was produced before the trial court and the trial court has taken that consideration. My lord, page 38 of the writ petition.
30?
38.
Yes.
May I read, please, my lord?
Which para?
My lord, para 10, it runs from page 37.
Please read.
On perusal of the records, the above matter is posted for cross-examination of the petitioner. At this stage, the above IA is filed by the respondent by praying to grant an interim maintenance. The contention of the petitioner that the respondent is working in a garments factory and having an handsome salary of rupees, getting salary of rupees 30,000 per month. In order to establish the same, produce the Xerox payslip of the garments factory by name Phenomenon Fashion Private Limited for the month of May 2023. On perusal of the same, the
No,
gross salary.
has she accepted this fact that she's earning 12,926?
She was earning.
Huh?
So sorry, she was earning.
Hmm.
So, but now she is not working. She is,
Please come to para number 11.
on other hand, the counsel for the respondent reduced the application given under Right to Information Act to the General Manager, ACE, multi-access system to get the salary certificate from January 22 to January 23.
When is this application filed?
My lord, 24/6/2023. I have produced the latest salary slip, please, my lord, before the family court. I have produced for the month
Please,
of
one
May.
minute. This petition, application for maintenance filed when?
My lord, when the stage was posted for cross-examination of PW1 on 24/6/2023
Was the application?
was the application, IA number 2.
According to you, from when to where she was working?
Please, my lord.
From in which period she is working in that company?
My lord, I have been told that immediately she deserted me in the year 2019, please, my lord. She has been working in this particular factory. That is the limited information which the husband has.
Thereafter, now, as per your, whatever that you have placed before the court, as per the set pay slips, till what time she is working there?
My lord, as on today, she is working.
Where is the document?
My lord, before the trial court, please, my lord, I have produced the latest, my lord, the previous month. Why? Because
Which month you have produced?
my lord, May 2023. Application was filed on 24/6/2023.
Have you filed any application after May 2023?
No, my lord.
Any receipt? What is her case? Let us see the petition that is filed, seeking maintenance.
And moreover, please, my lord, no assets and liabilities.
No assets and liabilities. She must have filed an IA for this interim maintenance. In that she must have stated what it is.
But in the application, she has not stated as to with respect, she has suppressed that with respect.
At least has she said that I was working earlier in this company?
No, my lord, she has not stated anything.
Then when there are that kind of suppression of facts.
But in
why
my
should the court
statement,
consider it?
my lord, in my statement of objection.
No, my lord.
Where is your
My
petition?
lord, when she was in Bangalore, along with the husband, he has forced the respondent to go to the work for garments. So when he was forced to go to the garments work, she has worked. And when he has harassed
No, this is MC is 2022.
Please, ma'am.
You were working in that on 24/6/2023 as on May 2023. How can you say that because of his harassment you're working?
When she was in Bangalore in 22, my lord. 22, she was in working. Now she has not working.
2023, May 2023.
Now she is in her parents' house in the village.
Please tell the court, where is your petition seeking maintenance, that what do you ever call it, application, petition, IA, that you have filed seeking maintenance? What did you say in that?
I have not filed any application.
No, without even filing all that, how this is numbered?
Please.
My lord, I have the payslip, please, my lord.
Not the payslip. Where is your IA? IA objections, then the order, isn't it?
Please, my lord, I have
Where is
produced the
IA?
application at Annexure C. It's in, my lord, my in Kannada. It's in Annexure, see page.
What she says in Kannada?
My lord, the only relevant portion in respect of the maintenance is concerned, please, my lord, it starts from page 19. My lord, the second para, which she would say, my lord, my read and I'll translate. ಆದ್ದರಿಂದ ಘನ ನ್ಯಾಯಾಲಯವು ಕೃಪೆ ಮಾಡಿ ಸದರಿ ಅರ್ಜಿಯ ಅಂತಿಮವಾಗಿ ತೀರ್ಮಾನವಾಗುವವರೆಗೂ ನನಗೆ ಊಟ, ಬಟ್ಟೆ, ವಸತಿ, ಔಷಧೋಪಚಾರ ಹಾಗೂ ಇನ್ನಿತರೆ ಖರ್ಚು ವೆಚ್ಚಗಳಿಗಾಗಿ ಅರ್ಜಿದಾರರ 20,000 ಮಧ್ಯಂತರ ಅರ್ಜಿ. My lord, till the proceedings are being completed in the proceedings, please, my lord, in respect of food, shelter and other medicinal problems, medicine, please, my lord, she required 20,000 as a maintenance. That is the only.
Where is the averment about her employment? Where she was working, she is working.
my lord, in my statement of
Not your
objections.
statement, in her statement, I'm asking.
My lord, in
What
her
did she
statement,
say?
please, my lord, she has not stated anything.
Nothing, whether she
Nothing.
was working earlier.
Nothing, she has
is
not
work-
stated anything.
Nothing.
Nothing.
Huh. Now, what is that payslip? Please pass on.
My lord, I-
It's there in the second para.
Second, read it,
It's there in the second.
read it.
ಅರ್ಜಿದಾರರು ನನ್ನನ್ನು ಯಾವಾಗಲೂ ಅನುಮಾನದಿಂದ ನೋಡುವುದು, ನನಗೆ ಮಾನಸಿಕವಾಗಿ ದೈಹಿಕವಾಗಿ ಹಿಂಸೆ ಮಾಡುವುದು ಮಾಡುತ್ತಾ ಬಂದಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ಅರ್ಜಿದಾರರು ನಾನು ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಕಂಪನಿಗೆ ಹೋಗಿ ಅಲ್ಲಿಯೂ ಗಲಾಟೆ ಮಾಡಿದ ಕಾರಣ ನನ್ನನ್ನು ಕಂಪನಿಯವರು ಕೆಲಸದಿಂದ ತೆಗೆದು ಹಾಕಿರುತ್ತಾರೆ.
Date
He was
of
made
joining.
galata in the company itself. They have removed the respondent from the work.
Said that she has not stated anything.
my lord, my lord, what she has stated, she stated that prior to that, my lord, this petition is filed in the year 2022. My lord, she stated that, my lord, respondent wife was compelled to go to work, and later on, please, my lord, since the petitioner had made the letter, she was compelled to remove from the, my lord, no documents to that effect, please, my lord, is forthcoming. It is nothing but a,
This is when,
my lord, this is of the year, the 2023, May 2023.
where do you get that?
My lord,
It appears only 2022.
my lord, that date of joining, may I kindly see, please, my lord,
But
in
it's
right side,
2022.
right side, my lord, from the top. Date of
Date of
joining is
joining
on
is- that is
31,
While you were, while
2022.
she was with you, that's what his
Well,
argument.
no, when it is not. She deserted me in the year 2019 itself.
No, leaving that, you said 2023 is the pay slip. Where?
Please, my lord, May 2023, my lord, I'll go. Or else I'll produce that relevant period of the pay slip also.
Madam, my lord, that has been considered in the order. ma'am.
Let's see that. That. Where did the court consider that why the wife had not stated all this? That is relevant. And why without the statement of assets and liabilities, why the maintenance is granted? Is it not supposed to be done? When is this order passed?
My lord, in the
2024.
Then why Rajneesh
March
versus
20.
Neha will not apply?
my lord, it is for the month of May 2023 in the top. It's
Take
mentioned.
that.
Yes.
Show it to him also.
The name of the wife is also being reflected, Pratima AS. No issues.
Yeah.
For the month of May 2000.
Agreed with the orders passed in.
But I have to ascertain all these things. Maybe kindly have it next week, please.
No, next week, tomorrow.
Please.
At the request of land council, the respondent poses matter tomorrow. Land council submits that with regard to the pay slip, which the petitioner is mentioning, a counsel of the petition is mentioning, he'll get specific instruction. Tell your client,
I may be
tell your
permitted-
client that I'll direct the court below to initiate proceedings against her for perjury.
I may be permitted to take one copy of it.
Give a copy to him.
I'll produce and I'll place it before you.
Yes. And place that also by way of a memo tomorrow.
Please, ma'am.
And tell your client the court is going to pass an order. No, when the court, considering the difficulties of the wife, is coming to the rescue of her and passing orders, she should be fair to the court.
Please.
She should come to the court with clean hands, not like with all this separate.
My lord, that has been made. in the-
Considered, but
That
that
has
is the
been considered in
difficulty.
the order. ma'am.
That
That has
is-
been
but the-
considered in the order.
But the court, why the court can grant maintenance to the wife who has not stated the correct facts? No, the court considered that she's earning 17,000, which is not sufficient in Bangalore. Who stopped her from telling all that? And first of all, without statement of assets and liabilities, why the court had considered this application?
Please, please. That has to.
Yes,
Cell number 11,
Kindly have it day after tomorrow.
day after tomorrow.
cell number 11, Manjunath NM for petitioner. Garaja.
I pay for respondent money.
She says some difficulty.
What?
She says some difficulty to the respondent counsel.
Yes.
She wants adjournment.
Rest time.
Pose this matter, which is the next state where list matters are there.
Interim order may be extended.
List matters are there. Pose this matter on 19th at the request of land counts for the respondent. Interim order earlier granted is extended till the next state of hearing. Yes, next.
Cell number 12 adjourned, cell number 13. Chandranath Ariga K, petitioner.
Today order dated 13/8.
They have filed one salary slip. Based on that, my lord, your lordship has passed an order which was
Already
1
read.
lakh rupees was earlier, it was granted by the.
No, let me
trial
just
court,
look
my
at the interim order. What is that the order is passed? by?
Order is for 10,000 rupees is directed by.
So petition on the wife is.
On the basis of the
working
salary.
with this company and the petition is drawing a salary of rupees.
That's
Taking care of educational expenses of both the children, but the court will have thought any basis without recording any basis. And hearing had granted maintenance on submitted, that's very difficult for him when he's getting income of. You want to pay, considering the submission, there shall be stay of all, but the condition that he continues to. How much the court had granted?
1
Like,
lakh,
huh?
1 lakh, my lords.
Trial court has granted 1 lakh rupees based on his salary slips, my lord.
What is the wife earning?
My lord, no, she is not earning.
Lords.
She has already resigned the.
His
After
salary is
filing
how
of
much?
this petition, says
Earlier
inside.
job was there.
No,
They
his-
have, yes, my lord.
His salary is how much?
47 was there, 47,000. And they have mentioned that 1 lakh rupees she was earning. That is one false statement they have given.
No,
And
how much the court had granted now finally?
10,000 rupees. my lord.
10,000 is granted.
Yes,
Ah.
and his salary was, my lord, as per his salary slip, it is showing that 4,27,000. And he fails to file his assessment liabilities before the trial court. And therefore, my lord, the 1 lakh rupees was granted. No, my lord, they have shown before this honorable court showing that the net salary which net pay salary is only he is showing that 1,02,000 out of 4,27,000. And later they are going to say that, my lord, that salary slip is older. And now recently one more salary slip is issued by the company that they have undertaken that they are going to produce before this honorable court. And last time your lordship has directed him to produce the latest salary slip, where it shows that, my lord, double of the amount. And while taking that order, my lord, they have made the submission that wife is earning and the amount which she is ready to file that affidavit also, my lord, 47,000, which has already been filed in assets and liability, which we have shown, my lord. Here they have suppressed the
On that
facts.
day, they submitted before the court that his income is 1 lakh.
1 lakh. That is one thing, my lord. And his income is, my lord, the 4 lakh, that is in page number 76, my lord, and we see all his investment, everything he has
No, no,
reduced.
this order is passed on 10/7/2024. As on 2024, what is his income?
Whose income? His income was more than 4,27,000. According to my client, my lord, that is the respondent, that he is earning the
Where is
per
your
month
page?
salary is 8 lakh rupees per month.
Let
It
let
is
him
more
pay the
than
pay.
8.
That's by order dated 13/8/2024. This court directed me to explain my salary slip that is at annexure G. To that effect, I'm filing a affidavit.
No, why should you say, tell the court that your salary is only 1 lakh? You should, even on that day when obtaining an interim order, that's the reason why I don't grant interim order without any, without, the reasons for that.
Please.
So you tell the court that my salary is 1 lakh. Can
Please.
you say that if after deductions it's 1 lakh is a different issue? Your salary will not be 1 lakh.
That's that particular day, the matter was called at about 5 o'clock. I had even mentioned to the court that if annexure G can be looked into, and my net pay, my take home is at
Understand
1
when the
lakh.
court is dictating the
Please.
order, you are there?
Please, I
Very
was
much
there.
present.
Please, I was there.
If some of the facts which are not correctly understood by the court,
Please.
as you say now, then you should have told the court that what you're dictating is not correct, my salary is this.
That's not, I have placed this annexure, I have placed this, not to make any false statements. This annexure is already on record. I could not go against what is
No,
there on
this 1
record.
lakh where from the court has got according to you.
No, that
Who
is the
says
net
it?
pay. That is the net pay as per salary
1 lakh
certificate.
salary and 1 lakh is
Well,
your
that's-
take
To
home.
that effect, I'm filing an affidavit as directed by this court.
And now, even recently, my lord, on last date of hearing, the lordship has directed him to produce the latest salary slip. my
I
lord.
have produced it with
Oh,
the affidavit.
all this matrimonial matters, all the wife and husbands have become litigants, more of, these kind of, how to get over law, how to,
deny the other party the relief. That has become the order of the day now.
But that is not the intention, my lords. Kindly look into this.
You can't you pay 10,000?
My lords, I have paid, I have not denied. Kindly look into my petition which I filed before the trial court for divorce. In that petition itself, I state that I have been paying 15,000 to my wife as maintenance. That I have already placed on record in the petition before the trial court. I have never said I will not pay.
Please come to this.
Let's kindly come to ink page number 31 in my petition, my lords. At paragraph number 39.
The gross earning is 4,27,971. The basic earning is rupees 2,13,986. House rent relevance is 85,594. Telephone allowance 5,000. Professional so and so. How are you paying this much of provident fund?
Well, that is deducted by the company. I am not paying. That is straight away deducted by the company.
3,52,880 per month.
No, that is not the, sorry, my lord, I'm mistaken. Of my petition, affidavit. Deductions towards provident fund is at 25,678.
Let's calculate it. 25,000 is your provident fund. Yes,
Please.
next.
Then there is a professional tax at 200 rupees. Let's allow me to explain. What happens is in the IT field across the industry, since more particularly in respect of the petitioner herein, he is having an income of more than 50 lakh per annum as per the salary certificate. When income is more than 50 lakh as per the salary certificate, there is a surcharge that is deducted by the government towards the income tax as 10%. So 30% flat because of his income, that is above 12 lakh. Then comes his, because it is more than 50 lakh, that flat 10% surcharge is deducted. That is
That 10% only on the tax, my lord, not on the salary. If it is, my lord, on the tax is 30%, approximately it may
I am
come
not-
for
If what breakup you're giving, if
Please.
that's the case, then don't have to work. Then don't take a salary of 4 lakhs because you'll get only 1 lakh.
that
take
is
home.
not, no, whatever amount that exceeds 50 lakh, 10% is deducted. As per that, I have given a calculation. I'm not saying 10% on the whole of 50 lakh.
No, what you say is your salary is 4 lakh, except provident fund, entire amount you're paying towards tax and you're taking home 1 lakh.
No, my lords, kindly see the salary slip.
Here, I'm looking at your affidavit.
Please, that is what happens. I would like to explain that, my lords. What happens is, since he's earning more than 50 lakh, there is a flat 30% income tax that is deducted. Then 10% surcharge. What happens is, monthly they deduct, based on his performance in the company, they deduct 25% for that particular month. Next month, say 28%. Then the next probably month, say about 30%. So what happens is they don't straight away deduct 30% till January, February, and March of the subsequent year. Only when it comes to January, February, and March of the subsequent year, they deduct the remaining portion of the tax. Because the remaining portion, say if.
So what you say is your salary is 4 lakhs and after your tax deductions, you take only 1 lakh home. And your salary is 1 lakh, that's it. If you pay the taxes, what remains? With you?
No, my lords, it does not come to that. There is all these travel allowances, what are there? There are allowances, kindly explain.
How much it comes? That we have
It comes
to
to at
see.
about 1 lakh back then. When this MC petition was filed, after filing this writ petition, my salary slip is at 1,92,000. My take home is at 1,92,000.
Yes, 1,92,000.
1,92,000.
Yes.
That is
But-
annexed to this affidavit.
Then what is that you are paying towards the children's expenses?
My lords, I am taking care of the children, all their educational expenses. The son is with me.
Can quantify that. That's
My lords,
what
I
the
put it
court asked you
I put it
to-
across. More particularly,
Tell the court.
my lords, I have stated in my petition, my lords.
Please.
My lords, particularly one point is that the house which I used to live in, I have given it up for my wife.
That's what you better tell.
I
that
stay in
to
a
the
rented
court.
premises.
That you better tell to the
Please, my
court
lord.
what it
My lords,
is.
kindly come to ink page number 31 of my petition, my lords.
You can tell, I will write that.
There is a
Note down
statement which I
that.
made in my petition before the trial court.
What is that? What is that you're paying?
Petitioner
towards
is ready to let the respondent stay in his house with their daughter. He is also ready to pay her monthly maintenance of rupees 15,000 so that she
it?
can.
Ready, what are you paying right now?
Right now, 10,000 I'm paying. That is as per the court order.
You're mixing the facts. I said, you said, I'm taking care of the educational expenses. of the
I'll
children.
explain that, my lords.
How
Pardon.
much is that?
Please, my lords, the educational expenses of the children would be at about 2 lakh. Their school fees, their transportation fees.
Are you disputing it?
That is, we are disputing it.
Huh?
Yes.
Are you disputing that,
Yes,
that he is
disputing
not
that
paid?
he has not paid that much of amount, my lord. And he is not receiving the call at all. And one son, my lord, is staying with the petitioner and daughter is staying with the respondent.
What is their age?
Age of the petitioner, the first son is, my lord, maybe around 10 years or 11 years.
Daughter?
Daughter is 4 years old. When she was 2 years old, that
Both the
time he
kids are
left.
now, both of them have shared. One is with her, one is with you.
Without her knowledge, he has taken away of first son.
Yes.
When he was in school, that time he took the first son and finally he blocked his mobile also. And he is not allowing her to visit the child also. So all things are happening, but now the issue is that, my lord, prior to the order, before filing of the MC petition, he was paying 15,000. 15,000 rupees, my lord. And after that, my lord, the trial court has ordered for 1 lakh. And later, my lord, they filed it and got it for 10,000 rupees. Even though, my lord, they are receiving the salary, because the total salary was 4,27,000. After deduction, according to him only, it is 1,93,000. Now again, he has filed one more salary slip, my lord, which shows that more than that now.
No, that is the latest
That's the
salary
part
slip
of
that
the
I filed at
party.
1,93,000.
How much is your take home?
Now it is 1,93,000, my lords, after filing of this writ petition.
You can pay 10,000, pay. Please come.
Lords, kindly note this. The house which I own, I have given it up for the wife. Now I am staying in a rented premises. And then she comes and seeks maintenance. After filing of this writ petition, she resigns from her job at TCS. More particularly, she has a business of sarees. She sells sarees in the house. And she has stopped that also. She has registered with the GST. She has a registered GST number. She has a business and she used to work. Just because I filed this writ petition, she now resigned.
That we will not, we are not considering that.
Please.
We are not considering that aspect, like whether she's entitled, why she has resigned and all. If she comes up with any other
Take care of
application
the
before the
child
trial
for
court,
4 years.
trial court will decide that. Just like that, because she wants maintenance from husband, she can't resign. That aspect
Please.
will be considered.
Please.
No, under these circumstances where your salary is 1,92,000, the maintenance of 10,000 is just, yes. Agreed with the orders passed in. Where is the order?
Let's page number 62, my lords.
Agreed with the orders passed in I number 3. In MC number 311 of 2020, whereby the court had granted maintenance of an amount of rupees 10,000.
Plus 1 lakh, my lords. The trial court had
Trial
granted an
court
order of
directed
interim maintenance of 1 lakh. This court had modified that to 10,000.
It is.
No, please understand.
Yes, ma'am.
Your salary is 47,000.
Yes, ma'am.
You have 47,000. You have a house to live in where the husband had left.
Yes.
So at least the house rent would be 30,000-40,000 per month. So another 40,000 towards that. That comes to 87,000. Husband is taking care of the educational expenses of both the children.
That matter, let him file an affidavit.
My lords, all these days they didn't dispute that I have been filing. I have the receipts. I shall file this.
How much it comes to?
My lords, yearly it comes up to about 2 lakh.
2 lakh.
Till
That is
date,
per
I will
month,
make
per month, how much it will be?
My lord, that is as per the school's salary slip, whatever, the school fee slip, whatever I will pay. I'll make a statement on record that I will not deny maintenance to the children in whatever aspect they need. In respect of the children, I will not deny them. The house is there. Even in my petition before the trial court, I go up to saying that even though there is a divorce, even if there is eventually there is a divorce, the wife can stay in the house with the daughter. I'm not seeking custody of the daughter also, because I know she's a daughter. Let her be with the mother. But all I seek is visitation rights. The son is with me. In factually, the son is cooking for me.
No, I'll record that. For both the children, he'll take care of the educational expenses. Yes. Then how the wife is entitled for 1 lakh as maintenance? You're staying in the house which belongs to him.
Yes.
No, I am in rent. I am staying in a rented house.
Staying in a rented, he's staying in a villas also, my lord.
Villa where, which belongs to him? How much rent it will fetch?
I'm paying 35,000 rent and 5,000 rupees maintenance.
That is 40,000.
The house where the wife is staying.
Please.
What is the rent for that?
My lords, the neighboring house, they are on rent. They are giving it at about 38,000 to 35,000 rent.
No, not at all, my lord. 25,000 maximum. It
Fine,
is a
my lord,
double
if
bedroom.
that is-
Oh, he's paying the educational expenses. He says that whatever is the children's maintenance, he will take care of it. Then wife is earning 47,000, let her be happy with it.
Because of the reason that wife, I mean, the child is, my lord, 4-year-old. So that to take care of the child, my lord, she left the job also. She's not working, my lord. And since without her knowledge in this, all of a sudden he left the house, then therefore she joined a company.
But she left the job.
Because after filing the writ
After
petition.
filing of that writ
Petition.
petition.
After filing the writ petition,
When the matrimonial proceeding, 2020.
2020.
So right from 2020, you are staying separately.
Yes.
That time when there was no necessity to quit the job, why it is now?
No, my lord, somebody was taking care of the child
No.
at that time.
She must be young in 2020. Now we are in 2024.
Yes.
Now what is the necessity to quit the job?
Because of the reason that.
No, maybe probably
Take
she
care of-
thought that to confirm this 1 lakh, leaving the job would be.
Not at all.
Let's kindly come
Not
to
at all.
page 77 at
reason
Annexure
that-
H, my lords.
Please understand anybody, whatever is the reasonable request or the reasonable requirement of the wife, courts are there to protect that. Not, no, even if now we'll accept that 1,90,000. No, he's paying 2 lakhs per annum towards the children, this thing. Then he has to take care of himself and a boy who is staying with him. Now the only girl is with you. You are in a position, no, whatever that house, you don't have to pay the rent, 25,000, 30,000. Then you stay somewhere, he'll give you the 30,000. Maintenance. Please get specific instruction from
I'll
your
have
client.
the specific
Court will not grant 1 lakh under these
That's-
circumstances. And you also file
Let's
before the
kindly
court.
see this, my lord.
You also file before the court.
The
What
expenses.
are the amounts that you are spending
Please,
towards the children's education?
Please.
That you
My
get
lords,
those
it may be
details.
recorded that the petitioner will not
That counsel for the petitioner submits
shy away
that the
from-
wife is staying in the house which belongs to the husband along with the daughter, and he is taking care of the son. It is submitted that the,
Taking care of the daughter.
and son.
Daughter is with the.
Daughter is with
respondent.
the son. That is what is.
that's what I said.
Yes.
So daughter is with the wife.
Yes.
He is taking care of the son and the daughter is with the wife. He is paying, according to the petition, he is paying all the educational expenses. And whatever are the expenses, he is always ready to take care of the educational expenses. He submits that the trial court had granted maintenance of an amount of rupees 1 lakh, which is on the higher side. According to him, as of now, his take-home salary is 1,92,000.
93.
93,000.
93.
As per-
1,93,000. Land counsel appearing for the respondent submits that also does not deny the fact that the wife is staying in the house which belongs to the husband. When it comes to the educational expenses, he submits that he has no specific instructions, whether he's paying the same or not. He submits that the court had rightly granted 1 lakh as expenses. Looking at one child is with the father and he is living in a rented accommodation. And he is taking care of that child and he has to take care of himself and other responsibilities. When the mother is working, why she has quit the job? When she last from 4 years she's working, why she quit the job at this point of time? And the reason that is stated by the learned counsel for the respondent is not convincing. By the next date of hearing, the respondent shall specifically submit before this court what are all the expenses that she is incurring for the child and why she had quit the job. And the husband also shall file the receipts of the school fees that he has been paying to the kids, and if any maintenance that he has paid to the kids all through, that also shall be placed before the court. Pose this matter on 25th of September.
I may permit you to file objection to his.
Yes. The affidavit that is filed with regard to the salary and the clarification is taken on record. Yes. Yes.
Sale number 13.
Please, oblige me.
12 again.
13, you call now?
Sale number 14. And then
I appear for the
Take
petition. Lords, I'm having the acknowledgement, having served the
respondent advocate.
Yes, sir. What's
Yes.
the name of the council?
Mr. Rishi Ruhiam.
And council submits that as per the orders passed by this court, he has taken out hand summons.
No, my lords, this honorable court had ordered. And I have served through RPAD, I have served, my lords. The advocate's name is Rishi.
Personal notice on the council appearing for the respondent before the trial court. And he has also filed the acknowledgement as per the same, it was received on 29/7/2024. Please, she is directed to print the name of Mr.
Rishi K. Ruhiam.
K. Raja,
Rishi K. Ruhia and Associates.
P. K. Ruhia and.
RUIA, my lords.
Rishi K. Ruhia and Associates.
Yes, my lords.
Yes, for appearing for the, as the council appearing for the respondent. Yes, next.
My lords, interim order may kindly.
Interim order earlier granted is extended to the next date of hearing.
Much obliged.
Post this matter next, thereafter, on 25th September. 25th. Yes, next.
Sale number 15.
Yesterday, my lord, the direction has been issued to furnish the copy of the miscellaneous petition along with IA, my lord. I may be permitted
that.
to furnish the same. My lord, the plaintiff appeal. Suit for injunction, my lord, the trial court dismissed for non-prosecution.
When was it dismissed?
My lord, on 21/7/2014.
21/7/14. It is dismissed.
My lord, suit filed on 18/1/2014.
Oh.
And defendant placed ex parte, my lord, in the month of March 2014. And for the first state, my lord, the case listed for plaintiff evidence on 2/4/2014. My lord, by mistake, my lord, along with the present suit, my lord, the plaintiff has filed 3 more suits. My lord, in that suit, my lord, the date has been given, my lord, on 23/4. But this case, my lord, the date given on 2/4.
So, when did you file the application?
My lord, application filed, my lord, on 24/11.
24/11?
2014. After I came to know that, my lord, I filed application for certified copy on 10/11. And my lord, miscellaneous petition filed, my lord, on 24/11. There is a delay of 60 days, my lord, in filing the miscellaneous petition.
Please come to the order. What did the court say?
My lord, the reason assigned by the trial court rejected the application. From the date of knowledge, my lord, has not been pleaded in the miscellaneous petition. I would like to take my lord attention to ink page number 21, internal page 10 and para 14 of the miscellaneous petition.
Suits for recovery of money.
No, injunction, simple suit, simply suit for injunction. Other suits, my lord, decreed against the defendant.
Notice is served.
Notice is served.
Jagadishwara for R1 and 2.
Please come. Agreed with the orders passed in miscellaneous number 884 of 2014. Dated 7th October 2017. The present appeal is filed. The appellant before this court is a plaintiff in the suit. Suit is filed seeking a bare injunction. In the said suit, the defendant was set ex parte in the month of March 2014. As there is no representation on behalf of the plaintiff, the court has dismissed the suit on 21/7/2014 for default. Thereafter, an application is filed to set aside the said order on
24/11.
On 24/11/2014. That came to be dismissed by the trial court. While dismissing the said, dismissing the miscellaneous number 884 of 2014, the court has observed that as per Article 122 of the Schedule of the Limitation Act, the petition for restoration of the suit has to be filed within 30 days from the date of dismissal. As
as the petitioner's counsel has taken the wrong hearing date and the date of knowledge of dismissal of OS number of 530 of 2014 has to be taken into consideration, and from that within 30 days, the petitioner has to file the petition for restoration, excluding reasonable days for obtaining the CC. From exhibit P1, it is clear that the suit was dismissed for default on 21/7/14, but the presiding officer, by signing the order, put the date as 4/8/2014. Application was filed for certified copies on 10/11/2014. And the application is filed on 24/11/2014. As within 30 days from the date of knowledge, as the application is not filed, the court felt that the appellant has not made out any case, not made out a case to condone the delay and dismiss the application, aggrieved thereby the present appeal is filed. And thus the notice is served on the respondent.
He's represented by counsel.
Notice is served on the respondent. And there is no representation on behalf. Yesterday also they were not there.
Yes, madam. Is not appeared.
Today, the matter came up on the earlier occasion, there was no representation. Even today also, there is no representation on behalf of the respondent. Learned counsel appearing for the appellant submits that. Yes, has mentioned that as to three other suits are mentioned as were listed. And there was he has failed to, has wrongly taken the date in that in view of the same, the delay has occurred. He submits that the delay is 30 days.
60 days.
Delay is 30 days, and it's not such an inordinate delay. The court ought not strictly considering Article 122 of the Limitation Act, ought not to have dismissed the application. He submits that the trial court, more on technicalities, had dismissed the petition. Next, for having heard the learned counsel for the appellant, there is a material on record. The application is filed to condone the delay of 60 days in setting aside the default order. The delay as stated is 60 days. And as observed by the court, for that period, the petitioner could not reasonably explain why the said delay has occurred. However, the said delay is not an inordinate delay. While considering the applications, the court has to weigh the interest of the parties and always lean towards the substantial justice. Unless and until it causes prejudice to the other side. In this case, considering the delay is not an inordinate delay. And delay, this court is of the view that the said delay can be condoned accordingly. So and so order is set aside, and the delay of so and so is condoned, and the suit is restored to file. Accordingly allowed.
That's okay.
That order, no, to remind. That's it.
The lot. And
No
serial number,
mentioning set 130.
serial number 16.
No mentioning set 130.
Oh.
Hello. ಅವಾಗಿಂದ ನೋಡಿ ಇದು ಔಷಧಿ ಎತ್ಕೊಂಡು ಸ್ವಲ್ಪ ಕಡಿಮೆ ಆಗಿತ್ತಲ್ಲ ಮತ್ತೆ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ
230 madam.
230 list 230.
Madam, serial number 37.
Sir?
ಯಾರೋ ಮೂವ್ ಮಾಡಿದ್ರಾ ಬೆಳಗ್ಗೆ? Serial number 37.
ಹಾ.
ಯಾರೋ ಮೂವ್ ಮಾಡಿದ್ರೆ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? 37.
37 ಇದೆ.
26 ಸ್ವಲ್ಪ ನೋಡ.
Data.
Twenty?
26.
Serial number 37 ಏನಾಯ್ತು ಮೇಡಮ್?
37 ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಸರ್.
ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ?
26 ನೋಡಿ ಮೇಡಮ್.
26 ಇದೆ ಸರ್.
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಪಾಸ್ ಓವರ್ಸ್ 2 ಇದೆ.
230 ಆದ್ರೆ
ಅದು ಹೆಂಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಹೇಳ್ತಾರೆ ಹಂಗೆ.
ಈ ಅಡ್ಮಿಷನ್ ಇರೋದು ಫಸ್ಟ್ ಆಗುತ್ತಾರಾ ಇಲ್ಲ 230 ತಗೋತಾರ ಮೇಡಮ್?
year period extension of time. Disposed matter. ಒಂದು ಎರಡು ಏನಪ್ಪ? ಅದಕ್ಕೆ ಅದು permission given to comply. IA for the ಸಿದ್ದಿಕಿಲ್ಲ. ಜಾಸ್ತಿ ಇವಾಗ ಅಂದಿಲ್ಲ. That is the fate of man. List number 3 for order, serial number 1, Gurudev Prasad KT.
The letter. By order dated 9/11/2023. Court had directed to dispose of the matter. To dispose of the matter. So a letter is addressed seeking 4 months' time to dispose of the case, considering the reasons stated. 4 months' time is granted.
Serial number 2.
This court by order dated 19/12/2023 has directed court to dispose of embassy number 1273 of 2016 within a period of 3 months. Now the learned judge has addressed a letter requesting 3 more weeks' time to dispose of the matter, considering the same. 3 months' time is granted. Yes.
Serial number 3. Vinay JS.
Hearing on behalf of the appellate manager, request for a week's time,
Yes, a week's time, default order.
please.
Cell number 4.
Seeks for a week's time, my lord.
Same default order.
Cell number 5.
Lord, in this case, my submission is that, Lord, annexure C and E are only the reference document. I filed a submission with regard to dispensation with regard to that furnishing of the typed copy.
Documents which you do not want to rely, don't file it.
It's only a reference document, Lord. Kindly see annexure E page 46 is the electricity bill, Lord.
Let's see. Annexure.
C, Lord, page 46, electricity bills, Lord. So another is annexure C. It is a khata extract that is there, that
Page number.
page number, Lord, that page 42, Lord. So this is in it appears that, but only with regard to that annexure E, Lord, is a electricity bill, Lord, that may be.
Submission with regard to non-furnishing of typed copies of annexure C and J. That is Kata extracts and electricity bills.
Not khata extract, yes, Lord.
With regard to non-filing of acknowledgement for having served copy on the caveator.
I will serve to that.
That
With
is
regard to
not
that,
expensive.
Lord, I will serve that.
With regard to the non-furnishing of typed copies of annexure C and J, the council submissions are accepted and the office objections are overruled. The council shall serve the copy on the
The caveator.
caveator by 18th,
Much.
or else appeal shall stand dismissed.
Cell number
No further
6.
reference to the court. Yes, next.
Cell number 6. Kumar JC.
That matter is settled, madam. I would like to withdraw.
It's filed.
Memo is already filed.
The memo is filed stating that the matter is settled under the court. Since I want to withdraw this writ petition, the same is taken on record. Memo is taken on record and dismissed as withdrawn. Next.
Cell number 7. Prakash Angry BB.
Here for
What is this memo for withdrawal of office objections?
I will clarify. I'll clarify. Week's time maybe.
The appellant shall comply with the office objections. A week's time is granted, same default. Yes, 8.
Cell number 8. Shilpa.
in this case.
You have received the copy.
We have received it, we have received it,
What is this IA 2 or 24 for prepare the appeal? Prefer the appeal. What is
Leave,
that?
leave.
Leave to
Yes.
file the appeal.
Lord, this, my lord,
1 of 24.
before reference court, but my lord, there is a common judgment so far as 3 cases are concerned. So 1 case is before single judge because of monetary, this thing, 2 cases before division bench. Yesterday, 1 matter was taken up before division bench and division bench has granted leave as well as stay. Subject to, I'm just filing the memo.
It can be allowed. So far as the application for condonation of delay is concerned, there is a delay of 570 days. I may be
Money?
permitted to file objection.
570, yes.
I may be permitted to file objection.
IA number 2 of 24 is allowed. Granting leave to the appeal for the appeal. In IA number 1 of 24, then counsel for the respondent seeks time to file his objections. It is submitted that already the copies are served on the respondent. When do you want, how much time you want?
A week's time.
I'm filing
this
this
matter after a
memo.
week?
I'm just filing memo to state that what happened in that other matter division bench.
A memo is also filed stating
stay
that
may be
in
granted
similar
because of the
matters, the division
execution.
bench has granted stay as well a leave to file the appeal. Post these matters on 18th of September.
So my lord stays.
Okay.
18th more matters are there, 24. 24.
24.
Yes,
Okay.
next.
My lord, stay, my lord, is,
Number 9.
stay is granted. My lord, I
We
mean,
are not aware of it. I'll file objections, madam.
just.
That's correct. but
No,
you are
when you're
serving it to
coming
me
up with
now.
a lot of delay, when you're coming up with lot of delay, no, please understand,
Yes, my lord.
it's a discretion of the court, granting
ma'am.
stay. Just because division bench has granted, this court will not grant. This court has to condone the delay. Then they're already there, let us give them an opportunity to file their objections to the delay petition. When the court is not entertaining delay itself, question of granting stay will not arise. So let's understand
No,
what
then,
it is.
my lord, they have filed execution petition. So let them,
What are you doing from those many days?
from 576 days. What is the reason for
We
the
were
delay?
not party, my lord. We were not
Oh, you were not
party.
party.
We were not
Who
party.
is, who is the appellant?
My lord, here we have preferred the appeal. We were not party to the proceedings before reference.
I
court.
understand.
Yes.
What is the decree? Who are you? What is the decree?
We are the, my lord, beneficiary of the land acquired, which was earlier with state government. Now that land has been entrusted to NHA. So I appear for NHA. So now whatever as per the law, whatever now financial burden comes, NHA has to bear that. So we are before this honorable court. Because ultimately, in reference, amount has been that has
How much
been
is the amount?
enhanced. I will this. It was 600, I mean 170 rupees per square meter was awarded by the
If that is 170, how much is the amount?
by SLO, which has been enhanced now to 6,456 per square meter from 170 per square meter to 6,456 per square meter. So now whatever that
732 per square meter. I don't know where she is getting that figure. 732 per square meter is, it is enhanced.
just see the judgment.
That's what it was 68 rupees per square feet. And now 732 rupees per square meters it is enhanced. So we'll file objection now.
Let's
I
just
mean,
see what
judgment.
it is.
I
File
request,
execution, you will not press for the till next week?
Please, Bill.
You will not press for the execution till next week?
I will
Next
not,
week.
I will not.
Land counsel for the respondent submits that they're not pressing on the execution petition. According to the same, poses matter on so and so for objections.
highly obliged.
9,
Highly obliged.
Which day?
cell number 9, 24
Same
9,
day,
sir.
24.
Hmm.
Great.
Cell number 9. Siraj Kashyap,
Seek for short accommodation to serve hand summons on the counsel appearing in the trial court.
Any interim order granted?
No, my lords.
Land counsel seeks further time for taking hand summons. Pose this matter on October 16th. Yes, next.
cell number 10, Arun Govind Raj.
Waiting for the respondent. I was supposed to file the assets and liabilities today. Wait for time to file the assets and liabilities, mainly because the respondent is down with influenza. I'll submit the medical records as well. And further, the senior has had a final hearing matter in the Honorable Supreme Court today, so it's flown out in the morning, my lord. So a short adjournment maybe in the next week.
I think last week, I remember.
Yes, ma'am.
Last time when the matter come up, when he has opposed, court has accommodated.
yes,
him. But
yes,
it can't go on every time.
No, my lord, it was just a short accommodation I'm seeking for. I'll have the assets and liabilities filed by this, served by this Friday and filed before this honorable court on Friday as well.
Very well,
You're
Lord.
going to post
I
it
have
for
no
next-
objection for them to take time. Lord, I've been visiting my children, my lord, in the apartment complex for 1.5 months now. From the 1st of August. My only request is kindly permit me to pick them up and take them. My lord, my parents are also coming along with me every time for visitation. I'll pick them up at 10 o'clock in the morning and drop them back by 5 o'clock in the evening.
Grant you adjournment this week, let him take them outside.
My lord, there's strong objections to that, my lord. I have actually prepared an affidavit.
You have object.
No, my lord.
Do what you're supposed to do for their thing, you have.
No, my lord, because there's serious grievance as such. The kid, minor son Zarin, he had come forward to the mother and had complained to the mother about the certain issues with the visitations, which the senior will be addressing before this honorable court. Accordingly, an affidavit was also prepared to file before this court. Since the respondent couldn't come down.
Counsel for the respondent finally post this matter when, Monday?
No,
Monday would be.
No,
Monday
I'm
would-
no,
Tuesday, 17th
I'm
also.
not in town till the 22nd, 23rd,
Fourth
23rd, 24th.
or 24th? Post on
Fri- 27th Friday, because miscellaneous matters run in the Supreme Court for the senior to, it's easier if you could
Every
accommodate.
time, this won't be as per your convenience. of
All right,
your
my lord,
senior.
anything as per this.
24.
convenience.
Lord, my request is
Much obliged, my lord.
their submission that the children are very comfortable with the father is on record already, my lord, before your lordship.
We'll see, we'll pass orders on that day, 24.
But then the visitation, my lord, the earlier visitation will happen.
The earlier is, visitation shall continue as per the earlier arrangement.
Number 11, Babu TC, Peter K.
For
the
petitioner, my
respondent.
lords, in this case, my lords.
Petitioner failed to comply with the order passed by the son.
No, my lords, in this case, the respondent in the trial court was not coming regularly in the trial court, my lords. So that's the reason we couldn't serve the notice of the same, my lords. Now they have come on record.
You do, yes, sir. Sir, give them papers. Have you served papers on them?
We have served through RPAD, my lords. We have served through RPAD. We shall give them the copy, my lord, short date can be.
Give him papers.
Entry but not.
And what about, then only you're appearing for all the respondents?
Only one.
Only
Only
one,
one
only
respondent, Land Council already filed wakalat for the respondent. Any stays in this?
Yes, my lord, stay has been granted. my lord.
ready?
Yeah,
You're ready?
deposit of pending.
You are
We have
ready,
deposited, my lords.
you are ready to argue?
Yes.
Argue.
My lord, short date can be given, my lords. We have deposited.
The
15,000 only award, yes.
it is submitted that they're complying with the Land Council petition submits that they're complying with the interim orders. The petitioner shall serve the copy of the petition on the council for the respondent. Post this matter for your preliminary hearing on 20?
Stay has been granted, extension of stay, my lord. Stay has been granted, extension of stay.
Interim order earlier granted. extend-
No, my lord, there is a conditional stay.
They have complied with or
deposited.
not?
If not deposited, stay shall stand vacated without further reference to the.
They have not complied with.
Not
We have,
complied. You
we have
not paid single
deposited,
pay.
my lords. We have deposited.
No, they have not complied, they have not
Where
furnished.
is that? Where you deposited? What is that?
My lords, I have deposited, but I don't have the copy. I'll just say the DD number, my lord. 6646766.
Okay, trial.
It is submitted that they have deposited the money before the trial court. Why DD number?
664,
Take that.
yes,
Give to her DD number so and so. What is the amount?
2 lakhs.
2 lakhs, and they have complied with the orders of the court. You have any objections, you can come up. Yes, next.
Serial number 12, non-compliance, third time, serial number
My lord, I
12,
appear for appellant. I pray for weeks' time to comply.
Yes, week's time, default order. Next.
serial number 13,
My lord, I appear for the appellant in the serial number 13, my lord.
Yes,
I pray for the week's time, my lord, to comply
week's
with.
time.
Much
14,
obliged.
serial number 14, Prakash Angri,
week's time, 15.
15,
Appellant.
Manu Prabhakar,
Grant the week's time.
Yes, yes, next.
Much obliged.
serial number 16, Rakshit Kumar,
No representation for dismissal in tomorrow's list. Yes.
serial number 17,
In the
My lords,
same list. In the
I appear
same-
for the appellants in the instant matter, my lords. The set, I appear for the appellants. My lords, the set's appeal has become infructuous as the parties have settled the matter and the same has been decreed before the trial court, my lords. So as such, if your lordship may kindly dismiss the matter.
Parties have settled the matter before the trial court. Hence this appeal has become infructuous, dismissed as infructuous. Yes, next.
Much obliged.
18,
18 and 19 weeks time, my lords.
Yes, 18, 19 weeks time.
serial number
Continue the
9,
list, not the passos.
yes. List number 1, serial number 16, VM Halaswamy,
Pay for the respondent. Lord, there is an interim order that is operating against me. Lord, status quo was against the.
You appear for the appellant?
VM Halaswamy,
Was there in the afternoon, the morning session.
No representation for the appellant. Pose this matter for dismissal tomorrow. Yes, next.
serial number 17, Vishu Baba,
I appear for the appellant. Filing the affidavit with
Revathi
respect to
Nath,
this court's order.
That they'll not,
will not do anything with the matter.
Please, lords.
Morning, I'm in the court, my lord. Copy is not served. Now they are serving.
It's
From
just
morning
an
I'm in the
undertaking that I'll not
No, you
create
could give
any
it
thought.
in the morning. What's wrong?
I was not there, but I was not there.
No, when the order is passed, when?
More than a week, my lord.
You should have given, no, everybody is, adopting this practice just before the matter reaches, they'll give it, it's not right.
Just an
As soon
affidavit.
They will get an opportunity, look at it. Undertakes that the appellants herein shall not create any third party rights or the who scheduled property. So
The
please,
order has been granted by the trial court. not
they
the-
want it in a different shape.
My lord, first of all, my lord, I have the translated copy also.
The documents, all the title deeds have produced before the court. Court is,
Why are you bothered? Ultimately, what order that's granted by the court? The same is now is going to be affirmed, but they
Not
want
in
it
the form of injunction.
in a different cup. That will give him what's, there's no problem. for
This
you.
writ petition is not maintainable because they are challenging the injunction granted.
Not a
on
petition,
the
my lord,
title
this is
deeds
first
verified
appeal.
by the trial court, madam. Title deeds verified by the trial court and all the entire evidence, what is before the trial court, last time they produced without
No,
translation.
What, it's like any other case where an interim injunction is granted, they're questioning where.
No, but title deeds this court can verify, madam. This
So,
court is.
this court, just listen to the order, what
Please,
the
ma'am.
court is going to dictate. Please, yes, please come.
And one more submission, my lord. Yesterday, they have completed plaintiff evidence, cross is completed. That proceeding with the matter.
The present appeal is filed, agreed with orders passed in I number 1 in OS number 309 of 2021. Whereby the trial court had allowed the I number 1 and granted temporary injunction restraining the defendants from creating any third-party rights dealing with the scheduled property in any manner on the strength of the lease deed dated 26/2017, pending disposal of the suit. The suit is filed. What is the relief that is sought in the
Declaration.
The suit is filed seeking declaration and for injunction. And for injunction. It is a specific case of the plaintiff that where is the plaintiff?
Page.
25 minutes. 75.
75
of the appeal memorandum.
It's a specific case of the plaintiff that he is the absolute owner in possession of the agricultural land bearing survey number 27 measuring 4 acres situated at Chikka Mudanehalli village, Nandi, Hubli, Chikbalapur, Taluk and district. And the same have been acquired under grant certificate dated 1/5/1973 issued by the Tehsildar Chikbalapur Taluk. And ever since the grant, the plaintiff is in continuous possession and enjoyment of the property. And it is their case that after a re-survey, it was allotted with a new survey number 43, and the revenue records were also changed accordingly. After change of the survey number, there were some discrepancies found in the revenue records. The kata of the scheduled property was reflecting in the name of defendant number 1. Hence, they have challenged the same before the Tehsildar Chikbalapur. And the Tehsildar found some discrepancies in respect of the kata and actual portion of the land and accordingly passed an order rectifying the same and holding the plaintiff as a katadar in respect of the scheduled property and the defendant number 1 as a katadar in respect of the property bearing survey number 23/1 measuring 0.35 untas. Thereafter, the plaintiff has made an application for change of use of land from agriculture to non-agriculture, commercial within brackets, educational purpose, before the office of the Deputy Commissioner Chikbalapur. And the order of conversion was passed. It is a case that basing on a fraudulent lease deed, the defendants are trying to dispossess the plaintiff from his valuable property by misusing the fact that the plaintiff was once associated with Sri Satyasai Baba Loka Seva Trust, Mudanehalli. In this regard, criminal cases were also filed.
There is one confusion which they are creating. The first respondent is not there. They are not representing the first respondent. First respondent is represented by the institution. They are representing which petition they have produced. Satyasai Lok Seva Trust, it is Alike, not Mudan. The first respondent, they are not representing the first respondent. They are for the other respondents.
So let's see the order. Come to the order.
Your Lordship, we can only see the trial court order itself, the court's title.
Temporary injunction granted restraining the defendants. Who are the defendants?
1, 2, 3, 4, 5, 6, 7. According to you, who is in possession of the property? Against whom you sought injunction?
Against all other than the second, in the petition, my lord. In the petition, they have.
Is it your case that all these defendants are, in what capacity they are in occupation of the property?
They are not in occupation. The possession is with the respondent, first respondent.
No, this affidavit is filed on behalf of whom?
Of the, I think the affidavit has been filed on behalf of third petitioner. Third petitioner has shown it. He has filed it on behalf of all the
appellants.
all the appellants, all the appellants.
Yes. Also filed. It's a case of the plaintiff that the lease deed dated 26/2017 does not hold good. As by creating the lease deed, the defendants have created an encumbrance on the plaintiff's property, posing a threat to the ownership of the plaintiff. And if the same is not cancelled by decreeing the suit, the plaintiff would be put to irreparable loss. Hence, they filed the suit seeking a declaration that the plaintiff is the absolute owner of the property, to declare the lease deed dated 26/2017 created by the defendant as null and void, and also to restrain the defendant number 1 and 7, and the persons claiming under them from interfering with their peaceful possession and enjoyment. Further, restraining defendant number 1 to 7 from creating any new documents or third-party rights in regard to the suit scheduled property. To the said where is the written statement?
Let's produce my objection to the item number 1 at page 54.
Where is the written statement?
The objection has been produced, madam. Page 54.
They have not filed a written statement.
We have filed the written statement of not produced, madam. That's my instruction.
Page 54 is the objection to the injunction application. Order 39 rule 1 and 2. Page 54.
You have filed your written statement. They have filed the written statement. Also filed their objections to the IA. It is a specific case of the defendants that. Where do you get the objections?
It's page 54.
They have filed their objections. And it's a case of the defendant that the plaintiff has come to the court. The separation of facts. It is stated that it is a case that they claim exclusive title to the property. Therefore, they deny that they are the leaseholders. It is the case that they've been enjoying the properties from 26/2017 without any interference. And now after 4 years, the sector cannot be curtailed by filing the instant frivolous and vexatious applications. Various educational and philanthropic activities are undertaken therein for greater public good. And the same ought not to be disturbed at the malafide intentions of the plaintiff. And according to them, the balance of convenience is in their favor.
And they've also denied about the new survey number assigned without notice to them. And also the resurvey that is done, that is carried out. The trial court, by order impugned, had granted the relief as sought for by the plaintiff. While allowing the said application, the court has observed that the materials which are placed before the court delete that. The plaintiff is relying on a grant which is of the year 1973. The trial court, relying on section 90 of the Indian Evidence Act, and where any document purporting to provide to be proved to be 30 years old is produced from any custody, which a court in the particular case considers proper, the court may presume that the signature and every other part of such document which purports to be in the handwriting of any particular person is in that person's handwriting. And in case of a document executed or attested, that it was duly executed and attested by the person by whom it purports to be executed and attested. Hence, the court came to the conclusion that the plaintiff had a prima facie case, and the plaintiff has come before the court with clean hands and has not suppressed any material fact and is entitled for temporary injunction. And the court further observed that the sued property deserves to be protected and maintained in the form and shape as it exists today, so that the rights of the plaintiff are adequately protected. The court observes that if the temporary injunction is not granted, and if the defendants alienate the property, then ultimately the relief which is claimed in the suit may be frustrated, and court cannot grant appropriate relief to the parties. And the court felt the balance of convenience is in favor of the plaintiff, and accordingly granted the relief. Aggrieved thereby, the defendant is before this court on several occasions. The parties have advanced their arguments. It's like when this matter came upon, when this matter came upon 2/9/2024, Learned Counsel appearing for the appellant defendant has submitted before the court that the defendant is a charitable trust, and they're taking up several the trust is carrying out several activities in the interest of the larger public. If in the order, if any orders are passed against the trust and its properties, it is not in the interest of trust as such. He'll come before the court with an affidavit that they'll not alienate the property. Accordingly, the matter is adjourned. Today, when the matter came up, Learned Counsel for the appellant defendant had filed an affidavit, an undertaking affidavit filed by which respondent is filed by the appellant number 3 on behalf of other appellants. Which reads thus, as it is right from here till the end, wherein by this affidavit, they have undertaken that they will not create any third-party rights for the scheduled property. Invoice number 309 of 2021, pending on the file of the third National Senior Civil Judge and JMFC, at Chikbalapur without prior leave of the trial court. Accordingly, this appeal is disposed of in the light of the undertaking given by the appellants that they will not alienate the property without prior permission of the court.
Milords, a specific observation may be made with respect to injunction that has been set aside by. A specific observation may be made, Milord, with respect to the injunction granted by the trial court. Milord.
In the
That may
light
be-
of the, why, what is to be clarified
Because,
now?
Milords, let them have an.
In view of the undertaking given by the defendants, there need not be any order injuncting them from alienating the properties. Who? Where is 16 point? Which case? You have filed wakalat for R2 also.
Bharati.
No, that is for the trust. What is I look saver trust?
Who
I'm an
filed?
individual.
Who filed? So Narayan, but. What is to be done? The notice to the wakalat filed by Bharati RB for R2, same is accepted. Yes.
My lord, serial number 60, my lord. We were ready for mediation, my lord. It may be referred to mediation, my lord.
Cannot not appear. It's posted for tomorrow, ma'am.
Tomorrow.
And we have discussed if there is a remote possibility of the matter being settled.
It may-
Short date may kindly be fixed, my lord.
Which,
Serial
case
number
number?
16.
16,
16.
all the three matters.
It is submitted that that's already posted for dismissal. It is submitted that there is a likelihood of settlement.
Yes.
You want to appear before the mediation center?
Mediation center.
The parties they want to appear before they want to go for the mediation. Parties shall appear when?
Any time,
Any next week, any date, my lord.
any date.
Any date, my next week.
Parties.
Thirty-nine
39.
at 3 p.m.
Yes.
Meanwhile, interim order are there in two matters.
Only
my lord.
granted the
16.1, 16.2 also connected.
Yes.
Great to oblige.
Public.
Yes.
Mediation Bangalore.
That-
Number 18. Nagaya.
Here for the appellant in this case, Milords.
What is this non-compliance of office objections? Is
No,
this-
it has been complied, Milords, on date. Yes, that is on 30/10/2023. It said that the office objection has been complied with respect to the submission made by the council.
Details stated in valuation slip to be correctly stated. If necessary, deficit court fee to be made to. What is this?
I'll verify it, Milords.
The office objections shall be complied. Pose this matter on 26.
Please.
Yes.
19. Mithun.
For the appellate.
Appellant.
That's a short accommodation.
BC Ram Reddy.
I have for respondent.
Stays there.
No stay.
Pose this matter on 30th of September at the request of applicant. Yes.
Please.
Number 9, 20. Abhinav Ramanan.
Here for the appellant in this matter, my lord. I've challenged an order passed by the trial court. An application under 39(1) and 2. There's an appeal by the defendant number 8.
What is the suit for?
Suit is filed by the plaintiff seeking a declaration of title as the owner on the basis of adverse possession. And the adverse possession that is sought is under an unregistered, unstamped joint development agreement. Now, my lord, the entire suit is filed to overcome the proceedings that have been initiated by the bank.
What is the order?
I am a
granted?
successful auction purchaser. There is a sale certificate in my
What is the
favor.
order granted by the court?
Order wanted is to not to interfere with my peaceful possession, with his peaceful possession. When the possession has physically been handed over to me by an order of the court, I'll just produce the documents in support, my lord.
Please come to the plane. Where is the plane? Give that. I
Page
think
number
that's the count.
63, my lord.
Page number?
63. Where at page number 83, my lord. Sum and substance of the plaint, my lord, is just very too many fancy words, too many paragraphs. All of it is used to say that there is a
Doesn't even say when is it, where is it, how is it?
absolutely nothing. There are only 3 documents produced, one JDA. And now the only reason why I have produced this list of documents, if I may just point out
I think you
that
please come to page 8. Para 8 of that plane. Something is started here for the first time.
yes, correct. So that under an agreement dated 8/4/2008,
Let us read
the
that.
plaintiff submits that under an agreement dated 8/4/2008 with the defendants, they were entrusted with the significant responsibility of not just developing the land, but also navigating the complexities of its current occupancy. The defendants' relations with Lakshmi Narayana Rangachar and Prakash Gowda, who had long-standing informal claims legitimate though over the property, added layers/complications to redevelopment process of the suit schedule property. The plaintiff's role transcended mere construction. It involved engaging with these occupants in a manner that was both respectful of their historical ties to the land and aligned with the project's overreaching goals. This delicate balancing act required the plaintiff to negotiate equitable exits for these occupants, ensuring that the transition was.
What is a suicidal property?
Suit schedule property is there is a construction. There were many tenements. There was also a theater which was running there.
Is
And
it constructed by whom?
which was by the landowners. That
It's
theater
there.
has been in existence for the past about 30 to 40 years.
He has made some construction, no?
Now the original landowner had borrowed and he was in due of about 16 crore rupees. He did not clear the loan. Bank initiated surface proceedings as early as 2019.
Respondent is whom? Defendants are whom?
Defendants are those landowners against whom this person is saying that he has some right.
Not the bank.
Not the bank. Bank is also one of the parties. And I am the subsequent auction purchaser. Bank is defendant number 6. I am defendant number 8.
No, the original suit itself is filed against the bank, or bank is later implicated?
No, bank is also made a party. He is challenging, he is stating that there is a sale certificate. Now, if the list of documents which I have given, I'll just point out the sequence of when this plaint is filed and in what manner it is filed. Now, the first document that I have produced.
When the surface proceedings are initiated?
That is why I produced this document, my lord. 29th November 2023, I have purchased it in an auction. The recovery certificate is as early as August 2019. August 2019 itself, it was NPA and recovery certificate is issued. The first document that I have produced, my lord, 20th December 2023, possession under 14 is taken through an order passed by the second additional magistrate.
Yes.
If my lord may kindly take ink page 9.
Yes.
Another contention, para 11. Lord,
Yes.
my lord finds it.
Yes.
Another contention raised by the respondents is that the petitioner has already obtained order to take physical possession of the petition scheduled property in CMIS. Previously also a CMIS was filed. And then subsequently it appears from the records that with the order dated 4/10/2019, the petitioner has taken physical possession. This is the finding before an order is passed, the operative portion, if it,
When is the physical portion taken?
my lord, there is a specific panchnama that has been done. That is at page number 25, 29th January.
20?
At page number 29. At 29, the bank addresses a letter on 23rd January. Subsequently, the panchnama is at page number 31.
Date.
29th January 2024.
When is the suit filed?
Suit is filed on 14th of March 2024. Now, my lord, before the suit is filed, the original landowners had challenged the sale certificate as well as the entire surface proceedings. There was an order passed by this court in both connected matters, which is at page 36.
What this court said?
My lords may take page 40. Now, KV Srinivas, my lord,
Yes.
is the original landowner. And he is the first defendant in the suit. And this person, the plaintiff, is saying that he is. And my lord, on 14th March, this order is passed. The same day, once the order is passed before this court, unstamped JDA. Now, my lord may kindly please take the order sheet. I just want to point out the anomalies in how the matter has been taken on board. Page number 47. In the list of documents I have just produced, my lord. Page number 47 of the list of documents that I have just produced, my lord. The order sheet is produced. On the left-hand side, my lord, it's page number 47. 46, the order sheet starts.
No, 47.
In the list of documents that I have produced now. 46, the order sheet starts, my lord. At page 47, plaintiff files a memo and prays to post the present case to CCH-15 since connected matter OS 4878 of 21, that is handwritten there, of 2021. There is absolutely no reference to any of the events that have occurred in 21. And then where A schedule property of that case and C schedule property in the present case are similar. And maybe then, my lord, there is also an office note which says may be heard regarding payment of court fee for use of section 24B on prayer 1. Since it's a suit asking them to be declared as
Lord, serial number 39, my lords. Lordships are not audible, my lords. No voice is coming, my lords. It has been muted, it seems, my lords.
I number 1024 is filed, seeking to withdraw the amount deposited by the petitioner as directed by this court. The I number 1024 is allowed. The respondent is permitted to withdraw the money post this matter on November 19th. Interim order earlier granted is extended till
Grateful, my lords.
Date,
1911.
Yes.
Cell number 40. For final. Shant Kumar KC.
This matter, short point it is involved in this case, my lord. They have prepared appeal against order 9 rule 13 application.
Many matters are there to me. Tomorrow is what day? Oh. Next week, there no next. That is on Friday. Friday? We'll have the Friday is small, very short list will be there. That day we'll have it.
Please.
On Friday.
Yes, 13. Tanveer Pasha.
No, all these matters.
Yes, ma'am.
41 for representation, then 41, 42,
43.
and 40.
I am for the appellant.
You're for the
Appellant.
40?
Please.
You're ready?
Any date may be fixed, my lords.
Huh?
Any date may be fixed, my lords. Records are called for, the arbitration
Urgent?
records are called.
Oh, this is the one. What this from, what is adjourned is 40,
40 is present.
41, 42, and 43.
Yes.
Will take up on 26th.
26.
Please. Oh, pleasure, please.
Cell number 44.
First petition, I'm the respondent. Matter was already heard in this 44.1, I'm a petitioner in the case. This is regarding the quantum of salary and 60,000 and net salary is 12,000.
We'll have it on 20th. These 3 matters on 20th. Let it be, let it.
20th. 2:30 or?
No, normal, then no 2:30.
29. 44 and 45 both. Cell number 46.
My lord, 45 I appear for
Not
petition
45,
respondent, my
it's
lord.
only 44. 45?
My lord, I appear for respondent, my lord. The petitioner are pursuing the matter, my lord. My lord has recorded the same thing in the last date, my lord. The husband has challenged the maintenance application, my lord.
We'll have it same on Friday.
No, my small submission, my lord. In this one, I'm following the order of this honorable court on IA number 1, and I've been paying maintenance as per the orders. The main petition is pending consideration before the family court, my lords. There's only one clause in the IA number 1 orders which says that I have to pay a penalty of 2,000 rupees per day in case if there is a delay for 1 day also. If that can be modified, I'll continue. This petition may be dismissed.
Mr. Counsel,
My lord, I couldn't hear. There is a
what
internet
he
problem, my
says
lord.
is that penalty clause in the order, that for every delayed payment, he has to pay 2,000. If that is modified, the remaining order is not questioning.
My lord, 18,000 was the order, my lord. Interim maintenance, water was 18 in the trial court, my lord. Now, before my lords, it has been reduced to 15,000. If 18 is regularized, my
That's
lord,
what
I
he's
have no.
saying. 18, you're okay with 18 or you're saying 15?
But what has happened apparently in this case is, my lord, in MC petition also.
We'll hear it. It will not happen like this. Post on that Friday, 20th Friday.
28/9.
Oblige,
Serial number 40. That is passed over matter.
Yes.
Is serial number 1 passed over serial number 1?
Not serial. What about the next one?
List number 2.
That you call, pass over later.
List number 2, serial number 1. Amar Korea.
Appear for respondent.
Let's we have.
Mount not.
Huh?
Mount not.
Milords,
Not deposited.
I have deposited, Milords. I have deposited it on,
Give the
Milords.
doc. What is the order of the court?
Order of the court was, Milords, within 4 weeks from the date of receipt of the order was the order of the court. Milords, I have deposited the money, Milords, on 28/8/2020.
5 month, 5,000 per month, you're doing it from there on?
Milords, 5,000 last month I have paid. I am yet to pay this month, I feel.
But it is by 5th of every month.
Milords, we are yet to get their account details. We do not have the account
How
details.
did you do it that another?
I gave it in the court, Milords, in the family court. This,
Then what about 1,75,000?
I have deposited before the registry of this on bill.
Give her the details.
Yes, ma'am.
Give him a copy of it.
Yes, ma'am.
Land counsel for the petitioner submits that.
Respondent, and the objection.
Land counsel for the petitioner submits that as per the order passed by this court, they have deposited for 5,000 as monthly maintenance for the last month. This month they are yet to deposit, and 1,75,000 they've deposited before this court.
By way
For this court by DD,
by DD.
by way of a DD.
Yes.
The respondent, and counsel for the respondent submits that he'll come up with his objections. The respondent is at liberty to withdraw the amount.
Milords, may I submit this? This about withdrawal, Milords, I may have my objections for this reason, Milords. The wife, Milords, is more educated than me. The wife stayed with the husband only for 2 months, Milords. And Milords, there is one more order passed of for the maintenance in domestic violence proceedings. He's been paying that, Milords. It is upon that submission being made, Milords. Milords had directed me to deposit the amount before the registry, and then them to come and make an application. Let them file an application.
Then what about 5,000? 5,000?
I will keep on paying, Milords.
The respondent shall give the particulars, the bank particulars of the respondent to the counsel for the petitioner. And for the objection of the counsel for the respondent poses matter on 14th of October.
Milords, one more submission, Milords.
Next week. Not possible.
In,
We'll have it on 30th September.
in fact, Milords have observed in the order, Milords, all further proceedings are stayed pursuant to the order dated so and so. Milords, what I had asked for in my petition, Milords, is.
What you might have asked so many, but the court wants to. put the-
However, Milords, all, instead of all.
That's the only order the court is granted.
Cell number 2, Raghu Prasad BS.
In this case, Lord, this petition is filed against an appointment of a receiver in a miscellaneous petition filed under section 92 of CPC. My lord, pendency of this petition, my lord, the original petition was dismissed.
But yes, the respondent.
My lord, the main petition was also dismissed, against which MFA was filed and it is allowed now. So, my lord, I had filed a memo on the last date of hearing.
They're not there.
Really.
Then-
Then, my lord, there are some office objections.
Then counsel for the petition is appellant is present, no representation for respondent. Poses matter on 14th of October.
My lord, in the meanwhile, I may be permitted to comply the office objections.
The petition, the appellant is at liberty to comply with the office objection. Yes,
Okay.
next.
Cell number 3.
For petitioner in this case.
Correspondent.
But yesterday the matter was listed, my lord. I was held up in some other court. Later on, I came and submitted, my lord.
Now, anyhow, at this hour, we can't take it. This also on the 20th Friday.
Now, interim order is there, my lord.
Interim order only granted is extended till then. Yes.
Cell number 4.
For the petition.
Cell number 4, Nagaraj R.
What is this original or certified? Then what you are filed?
My lord, this is with regard to the IA had filed with regard to the dispensation of production of certified copies, my lord. My lord, here the petition is, it's with regard to the
IA1, original or certified? IA2 with typed copy also.
my lord. There
What
was
you
a-
will file?
My lord, there was an urgency in the matter, hence not.
If original you don't file, certified you won't file typed also, then what order the court will know? What will be the order impugned?
My lord, I will furnish the type copies, my lord, but I will furnish the type copies, my lord.
It's so, if IA1 has to be allowed, you have to comply with IA2.
Yes, my lord.
Both can't be dispensed with.
Kindly, my lord.
IA1 of 2024 is filed to dispense the production of original or certified copy. Furniture C, E and B, F. The IA is allowed. I number 2 of 24, inspire to dismiss the production, typed copy of annexure D and legible copy of annexure F. As far as these two, are concerned, the petitioner shall furnish the typed copies. And IA 2 of 24 is dismissed. Yes, next.
My lord, with regard to this petition, your lordship had asked for a report to be placed by the trial court on the previous date of hearing. That was with regard to whether the trial court had sought for extension of time despite a time frame being fixed by this honorable court. Issue here, my lord, is with regard to the conduct of the respondent, wherein continuous adjournments were being sought for and all kinds of frivolous applications were being filed in the interregnum, due to which the trial has been dragged for a long period of time. That apart, my lord, in the application that was sought for filing the recalling of the stage of cross-examination, sufficient grounds has not been made out.
Court has already addressed the letter.
Yes, my lord. But then again, my lord, there has to be with regard to when a party seeks to recall the witness for the cross-examination, one certain factors that needs to be taken into.
Understand.
Yes, ma'am.
Now, you are before this court that in spite of an order of the court, they are not disposing of the case.
Yes, madam.
For that, there is an answer for you that they have already asked for the time.
Yes, madam.
Number 2, if in any of the order that is passed by the court, which ought not to have been, that you have to question it.
Kind of. My lord, here.
What is that you have questioned now?
My lord, the order that I've questioned is the impugned order that is in annexure A.
What is that?
My lord, that is the order passed wherein the application for recalling the cross-examination, the stage of cross-examination. My lord, that is in page number 20.
Have a chamber smarter at 5 o'clock. We'll hear it tomorrow.
Kindly,
On the
my
top of
lord, the trial court proceedings, it's
Tomorrow at 10:30. Simple matter, it can be disposed of.
my lord, let them not precipitate the trial court proceedings.
Morning.
Kindly. Because tomorrow is the next date of hearing before the trial court.
Let it be in the morning, it will come on the top of the list.
Kind of.
Tell that it is at 10:30 so that we. Yes. And even
Objections.
list number 1 as a
File it.
first matter in the list, something you mentioned. Because they have to understand. No, that I understand. In the second list, you mentioned that it will be called as a first case. Yes, next.
My lord, the objections, a copy of the objections may be served tomorrow before the filing.
Learn counsel, the respondent shall serve the copy of the objection. Pose this matter as a first case on the top of the list. Yes, next.
Passed over matter, cell number 1.
Yes.
Respondent said we collected the money, madam. On proxy, my lord, the respondent side is not there.
He is not there. Why proxy? What proxy is doing? You must have some instruction.
No, morning I am not there, my lord. My senior was there.
Where is your senior? You only asked for time.
My senior was some other court, my lord.
Pose this matter on. This also on 30th.
Petitioner.
Yes.
Request. Cell number 4. Cell number 4.
Understanding that the
Hearing for
matter will be
petitions.
dismissed.
We'll have it.
Your lordship's modified order, she has complied, my lord, that has been paid.
We'll have it on 20th. 20th.
20th.
20th. Please,
Friday. Yes.
please.
Post on 20th. Yes. For the
Please, madam.
petitioner. Yes.
Petition.
My lordship on submission, my lordship. Submission. Serial number 30, my lordship, it's adjourned, my lordship. Kindly extend the interim order.
Look at it. Interim order is there. It extended to the next date of hearing.
Serial number 30, ma'am.
ಇದೆಲ್ಲ ಸೈನೇ ಆಗ್ತಿದ್ಯೋ ಏನೋ ಸರ್ ಸೈನ್ ಆಗಿ ಹೊರಟೋಗಿದ್ರೆ ಗೊತ್ತಿಲ್ಲ ಇದು 29 30 ಬೆಳಗ್ಗೆನೆ
ಇಲ್ಲ ಇಲ್ಲ ಇವಾಗ ಕರೆದ್ರಲ್ಲ ಇವಾಗ
ಇವ್ರಿಗೆ ಆಗಿರೋದು.
ಒಂದು 10 ನಿಮಿಷ ಮೊದಲು ಅಷ್ಟೇ.
ಡಿಸ್ಮಿಸಲ್ ಇದು
ಆ ಡಿಸ್ಮಿಸಲ್ ಇತ್ತು ನೋಡಿ ಅದು. ಅದು ಅವಾಗಲೇ 30th ಡೇಟ್ ಹೋಗಿದೆ ಹೇಳಲಿಕ್ಕೆ ಮತ್ತೆ
ಇದೆಲ್ಲ ಮೇಡಮ್ ಸಿಗ್ನೇಚರ್ ಈಗಾಗಿದೆ ಇದು.
ಥ್ಯಾಂಕ್ ಯು
ಇದ್ರಲ್ಲಿ ಯಾನ್ ಮೇಡಮ್ಗೆ ಕೊಟ್ಬಿಡಿ ಫೈಲ್.
ಇಷ್ಟೊಂದು ಇತ್ತಲ್ಲ ನಾಳೆ ಅದು ಬರ್ದ್ಬಿಟ್ಟು ಇದು ಈಗ
ಜಾಸ್ತಿ ಇದೆ
ಜಾಸ್ತಿ ಇದೆಯಾ
ಅಲ್ಲ ಅದೇ ಅಯ್ಯೋ ಅಲ್ಲೂ ಅಷ್ಟೇ ಅಂತ ಹೇಳ್ಬೇಕಾ ಫುಲ್ ಹೇಳ್ಬೇಕಂದ್ರಲ್ಲ.
ಇದು ಪುಟಪ್ ಹಾಕ್ಬೇಕು ಇದು ಪುಟಪ್ ಆಗಿ ಬರುತ್ತೆ ಎರಡೇ ಕಳಿಸ್ತೀನಿ ಯಾವ ಡೇಟ್ ಇದೆ ಅದು
ಫಸ್ಟ್ ಇವಾಗ ಲಾಸ್ಟ್ ಆಯ್ತಲ್ಲ ಅಲ್ಲ ಟುಮಾರೋ ಒಂದು ಟಾಪಿಕ್ಸ್ ಲಿಸ್ಟ್ ಹೇಳಿದ್ರೆ
ಮತ್ತೆ ಅದೊಂದು ಹೇಳಿ ಒಂದು ಎರಡು ಕಳಿಸ್ತೀನಿ ಟುಮಾರೋ
ಇದೊಂದು ಬರುತ್ತೆ ಅಂತ ಹೇಳಿ ಮೇಡಮ್, ಲೇಟ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ. ಯಾವ್ದಾವ್ದಿದೆ ಗೊತ್ತಾ?
ಎರಡು ಫೈಲ್ ಕಳ್ಸಿರ್ತೀನಿ. ಎಲ್ಲ ಫೈಲ್ ಕಳ್ಸ್ಬಿಡಿ, ಯಾವ್ದು ರಿಪೀಟ್ ಇಲ್ಲ ಇಲ್ಲ.
ಅದನ್ನ ಆಡ್ದಲ್ಲಿ ಸದಾ ನಮ್ಗೆ ಹೇಳಿ
ಹೇಳಿದ್ದೀನಿ 3 ಪಾಯಿಂಟ್ ಬರುತ್ತೆ ಅಂತ ಇವಳಿಗೆ ಹೇಳಿದ್ದೀನಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ದೀನಿ.
ಇಲ್ಲ ಇಲ್ಲೇ ಇದೆ, ಇದು ಒಂದೇ ಇದು ಕಳಿಸ್ತೀನಿ.
ಅದನ್ನೆಲ್ಲ
ಸದಾ ರಾತ್ರಿ ಬರ ನೋಡಿ.
ಇದೆಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡ್ತೀರಾ? ಎಂಡ್ ಮೀಟಿಂಗ್ ಇದೆ ಅಲ್ವಾ? ಎಲ್ಲಿದೆ ಅದು?
ಅಲ್ಲಿ
ಇಲ್ಲ
ಮೇಲ್ಗಡೆ ಕ್ಲೋಸ್
ಇಲ್ಲ